The Child Care and Protection Act, CCPA, was enacted in 2005. That's false. The Child Care and Protection Act was enacted in 2004 to strengthen protection for children and promote their rights. The proceedings will begin in a few moments.
Almighty God, by whom alone kings reign and princes decree justice, and from whom alone cometh all counsel, wisdom, and understanding, we, thine unworthy servants here gathered together in thy name, do most humbly beseech thee to send down thine heavenly wisdom from above to direct and guide us in all our consultations. And grant that, we having thy fear always before our eyes, and laying aside all private interests, prejudices, and partial affections, the result of our counsel may be to the glory of thy blessed name, the maintenance of true religion and justice, the safety, honor, and happiness of the king, the public weal, peace, and tranquility of the island, and the uniting and knitting together of the hearts of all persons and estates within the same, in true Christian love and charity, one towards another, through Jesus Christ our Lord. Amen.
You may be seated. This Honourable House now resumes its sitting. House Leader. Today being Tuesday, June 25th, 2023, we will commence with call of the roll.
Mr. Bartlett, Mr. Holness, Dr. Clark, Dr. Chang, Ms. Grange, Mrs. Williams, Mrs. Malawi-Fort, Dr. Tufton, Mr. McKenzie, Mr. Chuck, Mrs. Vaz, Mr. Charles, Mr. Green, Mr. Warmington, Mr. Morgan, Mr. Hutchinson, Mr. Terrelong, Ms. Smith, Dr. Dunn, Mrs. Cuthbert Flynn, Mr. Main, Mr. Davis, Mr. Witter, Mr. Brown, Dr. Brownberg, Dr. Charles, Mr. Chin, Mr. Clark, Mr. Cousins, Ms. Crawford, Ms. Daly, Ms. Davis, Mr. Golding, Mr. Graham, Dr. Guy, Ms. Hamilton, Ms. Hannah, Mr. Henriquez, Ms. Crawford, Mr. Henry, Mr. Hilton, Mr. Jackson, Mr. Lawrence, Ms. Lee, Mr. Miller, Mr. Montague, Ms. Morrison, Mrs. Nita Garvey, Mr. Paulwell, Mr. Phillips, Dr. Phillips, Mr. Robertson, Mr. Robinson, Mr. Samuda, Mr. Shaw, Mr. Siblist, Mr. Slowly, Mrs. Vaz, Dr. Wheatley, Mr. Williams, Mr. Williams, Mr. Wilson, Mr. Wright, Mr. Robinson, and Mr. Hilton.
I would like to welcome our visitors in the gallery and those watching us via PBCJ and others in our various social media platforms. We hope that you will enjoy today's sitting of the House. House Leader.
Madam Speaker, I'd like to join you in welcoming members to this sitting, which is expected to be the sitting, the last sitting, in fact, for this session. Then we would recess for the summer vacation. Madam Speaker, we will have more to say about that at the motions for adjournment. The program for today, Madam Speaker, will flow as is. We will have a statement by Minister at a later point today, and then, of course, we will move straight through to the other items on the agenda. We may have a recommittal in the context of the reports to the House, because your Oversight Committee did meet today, and because the report is being prepared now, we will have it for a later stage of the sitting today. May it please you, Madam Speaker, to proceed with the agenda as stated.
Thank you, House Leader. Announcements.
Laid on the table of the House today are copies of the PIOJ's Economic and Social Survey of Jamaica for the year 2022.
Madam Speaker, may I just inquire, a couple of weeks ago, the Speaker of the House had indicated that there were reports from the Auditor General concerning matters relating to the National Works Agency as well as PICA. Last week, the PICA report was tabled on the basis that it's an executive agency. I'm asking, why has the National Works Agency audit report not been tabled on the same grounds?
The audit report for the National Works Agency is being tabled today. That's the discussion I was just having with the clerk, and it is on its way up for tabling. Not only is the NWA report slated for tabling. As you know, I had indicated last week I had just arrived before 2. My checks indicate that there may also be a report, a special report for the Transport Authority. Now, for the benefit of the public, I'm going to take the time to ensure, and the Parliament, that this issue is clearly understood. There is no difference in the views of the Deputy Speaker and the Speaker of the House. As a matter of fact, on issues that require special attention, there is substantial consultation. The Speaker was at lengths to ensure that not just the Parliament, but the public appreciated that as a senior attorney at law, she was very happy to be corrected by a junior attorney. And she was not at all ashamed to make it very public for all to hear. So there is nothing being hidden. All of us sat in the Parliament and previous parliamentarians before us, following a practice that we know with research have come to believe is incorrect. And the Speaker is absolutely correct in saying if we, by practice, are not abiding by the law, we should correct our actions. The executive agencies are few. There are over 140 public bodies. There are currently on the listing, as at March 2017, only 12 executive agencies. Once we started to look at the executive agencies and go over the records, the Administrator General's Department is one, Child Development Agency, the Companies Office of Jamaica, Forestry Department, Jamaica Customs Agency, Jamaica Information Service, Management Institute for National Development, National Environment and Planning Agency, NEPA, Land Agency, which is a National Land Agency, National Works Agency, the NWA, which is why we have asked to have it tabled today, Passport, Immigration and Citizenship Agency, which was tabled by me last week, and last but not least, the Registrar General's Department. So there is nothing untoward, nothing being hidden. Once we realize that we have not tabled a report that is for an executive agency, we will do so immediately upon picking up the error. I am going to reiterate, public bodies, for the appreciation of many in Jamaica, many do not understand why it is that one would pause to say that audits of public bodies should be verified to have been seen by the minister before such reports are tabled. I have been in the Parliament almost 7 years. Public bodies are not audited like ministries, agencies and departments annually, where the minister is expecting an audit, is expecting the permanent secretary to have a discussion. These public bodies are led by CEOs, executive directors, other forms of leadership and management that do not report directly to the minister on an ongoing basis. So it has not been a surprise to me to see ministers totally unaware, and if they are not at Parliament on the day a report is laid, the media will actually have far more knowledge of the contents of the report than the minister in question. Allowing the minister a period of no more than 2 months to be able to review, consult with the agency the issues identified by the Auditor General, and also speaking with the Auditor General in the event that there are issues to rectify, does not prevent a minister who knows of the situation, who has already verified, who is aware, to table or come and say, Speaker, yes, I'm fine. I have reviewed, I have agreed with the Auditor General that I am now aware. They can literally table immediately if they'd like, 2 days, 3 days, on the next opportunity available. So the outside limit of 2 months is not a stipulation that we sit and wait for 2 months. We take the people's business very seriously, and we want to ensure that a minister who operates in the executive arm and who has a significant responsibility as well to abide by the laws as a legislator in here is aware when being questioned about the contents of any report that is under their area of responsibility. So we continue to await. I've checked. We have not gotten a response from the Attorney General as yet, up to now. And I'm sure they're seized of the importance of responding as it relates to public bodies. However, until then, we will continue to lay only the executive agencies and follow what we appreciate to be the law until otherwise instructed.
Thank you.
Thank you, Madam Speaker. For the record, we see this matter fundamentally differently. We do not think that the law provides for this up to 2 months hiatus after tabling for a minister to indicate whether or not he or she has seen it. The practice of the Auditor General is to send draft reports to the ministries for the attention of the Permanent Secretary so that the minister can be appraised of the issues before they are tabled, and opportunities are given to the public bodies to respond to any issues in the draft report before the report is finalized. We think that this situation we're now in, where after years and years of established practice and convention, the Speaker comes to her own view on the law and then decides to seek an opinion, in the meantime changing the conventional practice and delaying the tabling of reports on public bodies, is quite inappropriate and wrong, and I want to register my strongest objection to this way of proceeding. And I can't understand why, in a matter of such fundamental importance, the Attorney General's chambers have not delivered this opinion to the Parliament. And I'm calling on them to do so without further delay. Thank you, Madam Speaker.
I will allow you in a moment, Minister. I will go further to say to you, though I've not been an auditor for many, many, many years, a draft report is not a report. A report is not a report until it is final. And so, though the Auditor General may or may not have made available to the Minister a draft report, when the rubber hits the road, it is at what is called, with the ministry, agency, department of government, public body, executive agency, though it may be, at that exit interview, you are given that final ability to resolve issues that the Auditor General may have found to be a concern that you are able to prove is not correct. You are able at that point to say, this issue, I can prove it should be removed from my report. You are at that point able to say, these are the updates, and I can prove to you this is where we are at the point of your exit interview. I can tell you my experience in the Parliament at least once. I asked the Permanent Secretary, and even at the point of the exit interview, the minister in question had no clue that the Auditor General was conducting an exit interview. So, opposition leader, I believe, separate and apart from the legal arguments we must look back at exactly what is the process and paper trail in ensuring that when a report is tabled, it is registered with the date required, and equally, when it is presented, that final report is presented to the minister, it is signed for as received by said minister, so that we know when time starts to run. The idea is not that you table first and for the minister to run around like a chicken without head, trying to respond to what they are not aware of. Member Vaz, you raised your hand.
Madam Speaker, thank you very much. Madam Speaker, thank you very much. I entered during the members' discourse with you in relation to the filing and tabling of reports. And I quickly inquired whether or not the member, leader of the opposition, had made any discourse or said anything in relation to his recent utterances on the political platform. Madam Speaker, I have a major issue. And I know that I speak for all well-thinking Jamaicans.
What is the procedure being followed by the minister at this present time?
I speak for all well-thinking Jamaicans.
On what basis
that
is
the
the
leader of the opposition has no moral authority to get up in this parliament and speak about any issue until he clarifies. Madam Speaker.
On a point of order, Madam Speaker. On a point of order, Madam Speaker. On a point of order, Madam Speaker. Why are you all behaving like that over there? Relax. Madam Speaker.
Minister Vaz, would you be so kind as to turn your mic off?
Madam Speaker, with all due respect, the minister rose on a matter where we are talking about the Auditor General and the tabling of the reports. Right? What he is discussing right now has nothing, no bearing. If he wants to raise it, he can raise it at the end. If he wants to raise it. If he thinks that it is a matter of national concern. But it has no basis in what we are discussing right now, Madam Speaker. So I would ask you to guide the minister in the proper way while we can finish having the conversation about the items that we're at.
Madam Speaker, just by way of clarification, the leader of the opposition did not speak on an agenda item when he sought privilege a while ago to ask a question in relation to a report. And so that was allowed. And so it is in the same context that I appreciate this response, that the Speaker is allowing a member to make a comment within that same space, because the item on the agenda was just after announcement by the clerk. The item was announcement. And the clerk didn't announce anything to do with any tabled item. The Speaker spoke to the issue after the leader appropriately asked his question. And there's no difficulty with that, Madam Speaker. It's quite admissible, allowable, and we are quite comfortable with it. In the same context that a member can get up at a point like this to ask a question. No, absolutely no difficulty with that. The member, Madam Speaker, you're quite in order to rule the way you did.
I'm really happy that the member is not speaking through the mic. At no point in time would I want you to refer to the Parliament in the way that you did. The opposition leader asked a question which I responded to and went into aspects of what is required by Constitution and law in respect of the approach that we are taking going forward, and the decision by the Speaker in being very convinced, having sought even legal advice within the Parliament from legal counsel here, but from an abundance of caution, is saying, I want to abide by the law and I am going to seek advice and counsel from the Attorney General's chamber. Every effort is being made to push that. I do not, as Speaker, want to even think about, nor would I have brought up the statement made by the opposition leader as I sit in the capacity as Member of Parliament in the seat that would have the dead vote. But I believe if a member stands up to speak on the same issue as I allowed the opposition leader to do, I can equally allow the minister to speak on the same issue, because it is one of equity and balance across the board. So I will allow you to finish, Minister Vaz, and then opposition leader, you may respond.
On a point of order,
Thank you very much.
I just want to.
The point of order is you must apologize to the nation. That's the point of order.
To the audit reports, non-tabling, when we were discussing announcements, because on the previous week there was a discussion and the tabling of the PICA report, and on the list of items tabled today under announcements, it did not include the National Works Agency report, and that is why I raised the issue under announcements. What Minister Vaz is seeking to do here is something totally unrelated to what we have been discussing in relation to announcements and the question of what is the content of what has been tabled here today. It is most improper and should not be permitted. It's an abuse of parliamentary procedure, and I'm not going to be party to that.
Thank you very much, Madam Speaker. Let me just clarify that what the leader of the opposition got up to speak about was constitutional matters. And that is what has
members, could you be so kind as to be quiet so that we can hear the member? Minister Vaz.
Thank you very much, Madam Speaker. No, I'll repeat. What and the reason why I have gotten up is because of the fact that the leader of the opposition got up to address matters that related to the Constitution. That's what got me. And I'm saying very simply that the decent, right thing to do, coming to the Parliament on the heels of that unfortunate statement, which is not theoretical or unfathomable, because it used to happen in the 70s. And that's why the Electoral Commission of Jamaica, which is named today, has done all these work over the decades to make sure that that is a thing of the past and is never brought back to the fore. So, Madam Speaker, I would have expected that the leader of the opposition, based on the position that he holds, constitutional position, the leader of a major political party, a member of Parliament in his own right, would come in this house today and not hide behind a statement to say his joke he was making. Have the decency and the respect to get up and clarify it himself, and if he needs to apologize, apologize. Madam Speaker, I refer to a statement just today that I saw in the news media that says the opposition remains committed to upholding the Constitution and protecting the democratic value that our nation holds dear. His utterances go in full contrast to that statement. Madam Speaker, wrong can never be right. Whether you hide behind it or
Madam
you go
Speaker,
hide
Madam Speaker,
to the leader of the opposition
Madam
today,
Speaker,
and a colleague member of Parliament,
Madam
that he must
Speaker,
do the right thing before he gets up and speaks on
Madam
any
Speaker.
issue in this Parliament.
No, Madam Speaker, with all due respect. No.
At large. What he did and said
Madam
is
Speaker.
unacceptable in any country and any democracy.
On a point of order, Madam Speaker. Madam Speaker, a point of order.
You tell me to raise it. Point of order is you tell me to raise it. You think it's 1 or 2 of your colleagues that
point of order, Madam Speaker.
Hold a moment, please. Take a seat. Member Phillips, take a seat. Take a seat.
Madam Speaker, I don't often get up because I choose my words and my time very, very carefully. And I'm saying to you that I, as a member of
all due respect, Madam Speaker, a point of order, Madam Speaker. Madam Speaker. Madam Speaker.
Member Phillips, hold a moment. No, number one, unless your point of order is different from the point of order that you had before. If you're raising the same point of order, you would have been allowed an opportunity. It is better to have the minister complete what he's saying because he's being allowed to do so. That has been the ruling. And after which, I saw Member Brownberg hold up her hand. She would also like to make a response. If you have a different point of order, go ahead. If it is the same point of order, allow Member Brownberg next.
Madam Speaker, with all due respect, you are allowing the Parliament to descend into a circus. You are. Right? You are. Yes, Mr. Phillips. Yes, Mr. Phillips. The member himself spoke about members over here colluding with him. If the member has any proof, Madam Speaker, then he should get up with proof and say which members over here has been colluding with him to make that statement. He said so. He said so, Madam Speaker. Madam Speaker, with all due respect. Madam Speaker, Madam Speaker, Madam Speaker.
Hold a moment. Hold a moment.
Madam Speaker, I believe we're being abused in here. And I believe
Madam Speaker,
that if this continues, a motion to sanction the leader of opposition is in order. Madam Speaker, I actually enjoy being heckled.
Madam Speaker, I am on my feet.
You have
Member
spoken.
Member Robertson.
I think member should take his
Member
seat.
Caldwell. Member Phillips.
I
Member
believe,
Phillips, take
Madam
a seat.
Speaker,
Turn off
if
the
this
mic.
continues,
Member
we are
Robertson,
going to have to move a motion to sanction
Member
the
Robertson.
leader of the opposition.
Member Roberts. No, I am asking that nobody else get up and address Madam Speaker. Everyone, please sit down.
Speaker.
No, please. Marshall, please have all the members standing. Kindly take their seats. All members take your seat and turn off your mic, including Member Phillips. I would love to be able to hear the discussion. I did not hear what Member Vaz had to say. I'm hearing a point being made by Member Phillips that I did not hear. And I'm actually trying to have it repeated so I can understand the statement that was made. I'm still at a loss. Member Robertson, you cannot stand up to make a point without making it clear you are rising on a point of order, which I did not hear. Okay? So if you do not rise on a point of order, you cannot speak. And Member Robertson, I did not hear a thing that you had to say. So I am going to say, please, for those who have already spoken, do not rise on a point of order again, because we have already heard you. Member Phillips, you're going to be allowed to complete. Member Brownberg wanted to say something. I will go with Member Robertson after, and then Member Vaz, and then we close, because I really did not expect to have this long debate. Member Phillips. Once we have allowed you to start a conversation on applying the laws which are actually designed coming from the Constitution for aspects of what we are discussing here, I get your point. When the announcements were read last week, in announcements, I tabled a report. You started on a discussion of the report being tabled. You actually asked, and I responded to you. My response resulted in further discussions about the legitimacy of the Speaker's decision in applying and following the law, which resulted in Member Vaz determining that he needed to get up and discuss the legitimacy of you as opposition leader speaking as it relates to constitutional issues, having made a statement that seems to imply you want the dead to vote. And so the discussion has started. I have to be fair and balanced and even-handed and allow you all to speak. So Member Phillips, Member Brown-Burke, Member Robertson, if he's in here still, yes, and then Member Vaz. And I'm going to close. House Leader, once Member Vaz is finished, I am going to make the decision to move ahead with the agenda while I have a chance to look at the reports that are currently in the registry as at this moment to ensure there are no outstanding reports that should be filed today that continue to wait until we resume Parliament after the break. So, Member Phillips, go ahead.
Madam Speaker, I rose on a point of order because the member over there made some allegations on members on this side. And if it is that the member has proof in what he said, the member said that members on this side colluded with him for him to make the statement that he is. And he needs to provide the proof or withdraw that forthwith, Madam Speaker. But at the same time, Madam Speaker, we're actually making a mockery of the Parliament. Because we have seen...
I am going to ask you to stop right there.
I'm not withdrawing that.
I am going to ask you to stop right there.
No, you are abusing your position there.
No.
Madam Speaker, you cannot...
Member Phillips, please take your seat. As far as... Take your seat.
Madam Speaker.
Take your seat.
No, Madam Speaker,
please
just like how you are going to have the other members be heard.
Please take your seat.
I would like to be heard
please
also.
Please take your seat.
Madam Speaker, I'm calling you to ask you also to name the member.
No, I am going to. I am going to. No, Member Phillips. Member Phillips. Member Phillips. Unless you can show proof that I am not even-handed and balanced in allowing the same latitude to members on both sides of the House, you need to withdraw your statement. And I do not appreciate for a moment that you would want to make a statement in this honourable House relegating us to a circus and a kangaroo court. Please desist from making such statements. It is not necessary in order for you to make your point. I heard you very clearly. And if you get up and repeat it again, I am going to ask the Marshal to name you. I am allowing you to speak. You have actually been disturbed several times and have gone right back to saying that you should get up and complete your statement. So balance has been given and latitude given once members would like to participate in the discussion. I have been fair. So do not stand there and abuse the Speaker.
Madam Speaker, the Leader of the Opposition made a comment yesterday, responding to the comments he made on the platform. Right? The Leader of the Opposition is not running away from facing whatever it is to face him. Well, Madam Speaker, the Leader of the Opposition rose on a matter to deal with the announcements, but also in a matter that the Speaker and yourself said that you have been waiting on a response from the Attorney General. It is in the right of the Leader of the Opposition to ask if that opinion has been brought to...
And he didn't ask that question.
He did ask the question. You can look back at Hansard, Madam Speaker. Right? And the issue has to deal with... The issue has to deal with governance. Madam Speaker, the issue has to deal with governance. And we are behaving in this House as if we have something to hide from the public. By every time that we come, something change, that we can't table reports. I can imagine that there are more reports that is here at the House waiting to be tabled than just the two that has been mentioned.
If you notice, you notice.
I'm asking the question.
No, you don't need to ask the question.
But Madam Speaker,
you do not need to ask the question.
Let us not relegate the Parliament. Again, I'm going to say it.
No, you don't need to repeat. Anything you have said, I've heard very clearly.
Yes,
once you're going to repeat, you need to take a seat.
And it ought not to be so, Madam Speaker.
No, number one. Number one, I didn't hear the opposition leader ask anything about the ruling of the... Let me finish speaking, please. Let me finish speaking. I didn't hear him ask the question. I know the question was asked last week. It was asked last week for sure. So in my discussion, in my statement, I made two statements that you are now alleging erroneously in your comment they weren't made. So I would like you to open your ears. Number one, I said, number one, I said that I am going to take the time while all the individuals are speaking to go through all the reports that are here in Parliament to verify that all reports that should be laid are rightly laid. That was number one. I sent to the registry and I asked them to take every single report that has reached the Parliament, and I made that comment. Number one, nothing is being hidden. We are extremely transparent. Number two, I went as far as to discuss not having received an opinion because the question was asked last week, and up to the start of Parliament, I still am not seized of such an opinion. Now, whether or not you think it is appropriate that the opposition leader and members of the opposition side are allowed to conduct themselves in a way that they are free to get up and to ask questions and to further lead into discussions on constitutional issues, the opposition leader opened the floodgates to being questioned on his authority as opposition leader, making statements that do not abide by the Constitution. And I am compelled, and I am compelled not to make these long statements. I actually am someone of very few words. I am not interested in being up here speaking. I allow the members to speak, and you speak to each other and to the nation respectfully. So I am going to ask Member Brownberg to speak if she still so desire. Please.
Yeah, Madam Speaker, thank you very much for acknowledging me. The Leader of Opposition rose on a matter that has to do with the governance of the Parliament and a decision that was made before and what is unfolding. I humbly submit that the question on which Member Vaz rose had nothing to do with issues in the Parliament. Madam Speaker, time and time again, individuals have said things on the political platform that we do not bring into the Parliament in this kind of a way. No one sought to bring into this Parliament whether or not everywhere garbage the PNP live. Nobody sought to bring it.
And it was a lie, but I can't answer to the Parliament. However, if you bring it up in here, I will also answer you in the Parliament.
That the member was out of order to have brought it. And I also want to submit that the members on this side have not taken any liberty that was not given. You allowed the leader of opposition to make the statement, and therefore you can't talk about him opening the floodgates, because if he opened it, then so did you by agreeing to him for him to speak. Madam Speaker, I believe that we need to use a bully pit when we have it in the right and proper way. You are not going to get members on the opposition benches to be quiet, because if we get up and ask a question, there are members who are going to operate in the way Member Vaz did. That kind of bullyism will not work with this opposition. So come and try and try and try again. It's not going to work.
Member Brownberg, I can see that you use the protection of the Parliament, and I will not even entertain or engage you. I have other places that I will be able to respond to you as it relates to the lie you just told. However, I will say to you, having allowed the opposition leader to get up and ask his question is absolutely an indication of the opposite of what you're saying. The opposition leader, someone on the opposition benches, at notification announcements, got up, asked this question. That wasn't the issue. He went further into a discussion, and I'll repeat, that resulted in Member Vaz raising to his feet, rising to challenge the statement made. Member Robertson, Member Vaz, and then House Leader.
Thank you, Madam Speaker. Madam Speaker, it has been reported widely that a constitutionally recognized member of this House has made comments that we believe on this side will at a later date, a later time, may give reason for us to rise a sense of motion. We believe the comments go far against our Constitution, our laws, and I believe at this point the decent thing to do is for me to call on him to make an apology and to withdraw those comments. Personally, Madam Speaker, in this House, I believe that he has to be more responsible on his platforms of what the utterances of individuals on his platforms, because I believe that we don't want to see our country taken back to the days where our electoral process is suspected. Madam Speaker, I do believe that his attitude in here is wrong, and the comments that I have heard, but I will not repeat. I will wait on that motion at a later time to deal with it, because I believe he needs to be a lot more responsible on his platforms. I now call on him to rise and to withdraw those comments made in East Rural St. Andrew and to apologize to this nation. Thank you.
Member Vaz.
Madam Speaker, and after all that has been said, let me go back to the point that I made originally. It is beyond discussion, debate, that the office of the leader of the opposition, a constitutional position, a leader of a major political party, and a colleague member of parliament elected by the people to represent the people, that his comments has brought definitively those three offices into disrepute. Undebatable. I would have thought, based on the position that he holds, that the first thing that he would have done in this Honourable House is to get up and deal with it frontally, as as a leader should, whether they are wrong or they are right. The second point is that without him doing that, for him to get up and speak on anything constitutional or anything else in this parliament, that he has no moral authority to do so. So that is strike two. And lastly, I, like the member from West St. Thomas, urge him, because it's never too late, and it's not too late, to do the right thing. There is people on this side, there's people on that side, there's people who support this side, there's people who support that side, and there are independent thinkers that are appalled at his content on Sunday night. Regardless of whether it is on a political platform or not, that type of discourse and those type of comments, as I said before, Madam Speaker, it is not theory that he's talking about. It's something that has dogged the political system from in the 70s. So it's not something that he's not aware of why he made the comments. It's not something him read about or something him dream about. It is real life politics in Jamaica decades ago. And that to me is the most important part. And I'm saying, without getting into any contention, because this is not a contentious matter. This is a matter of principle and morals. Nothing else. Nothing else. And I am saying that I feel so strongly about it as a member of parliament in this house, that if he does not do it, we will move to follow the processes to censure him and have a censor motion move, because it is fundamental to democracy. So, Madam Speaker, they can snowball it, they can smoke and screen it. Right is right. And nobody other than the member that I'm speaking about knows it, because he is a qualified lawyer, eminent lawyer in his own right. And therefore, he knows within himself that what he did was wrong. And what he must do is be man enough and responsible enough to get up and right the wrong. Thank you, Madam Speaker.
House Leader, would you like to make a comment in wrapping up this discussion, House Leader?
Madam Speaker, I beg to move. Madam Speaker, I beg to move for the recommittal of a statement by ministers, so as to allow the Minister of Education to make a statement at this time. May it please you, Madam Speaker. Madam Speaker, and in the same context, I beg to move that the agenda will then follow pari passu, as was stated.
Thank you, House Leader. Statement by ministers. Those in favor? Those against? The ayes have it.
Thank you, Madam Speaker.
Minister, I'm hearing the opposition calling for copies of your statement.
Okay. Madam Speaker, it's been circulated. Madam Speaker, I am pleased to report to this Parliament that Cabinet has considered and approved the expanded staff structure consisting of 832 additional posts that were identified in the post-audit conducted by the Ministry of Finance and the Public Service for the University of Technology. Cabinet also approved the current operational pay plan that is being utilized by the University of Technology, Jamaica, consequent on its increased responsibilities and program offering, since it was conferred with university status in 1995. I know as well that UTech is in talks with the Ministry of Finance and the Public Service regarding the compensation review, the university being 100% government-owned. Madam Speaker, for background, on September 1, 1995, the then College of Arts, Science and Technology CAST was conferred with university status and renamed the University of Technology, Jamaica. The University of Technology, Jamaica Act was subsequently approved by Parliament on June 8, 1999, and signed by the then Governor General on June 29, 1999. As a result of its new university status, the UTech Jamaica Act, requirements of the University Council of Jamaica, and requests made by the Government of Jamaica, UTech made several upgrades to its programs and structure consistent with its mandate to support national development through the provision of first-rate higher education. Adjustments in the staff structure would have also been the result of UTech's response to the requests of Government of Jamaica at various times to develop and/or implement programs needed to support national imperatives. This includes the request made in 1999 and supported by Cabinet Decision number 91/99 dated March 15, 1999, that mandated that the general training of health professionals be transferred from the Ministry of Health to the Ministry of Education, with the management and implementation of the training program to be undertaken by UTech Jamaica. Subsequent to this decision in 2008, the training program for registered nurses was also transferred to UTech by virtue of license and transfer agreement. In 2014, further to the 2008 decision, the Ministry of Health transferred the remaining training programs for midwifery, direct entry and post-basic, and critical care and nurse anesthetics programs, granting UTech Jamaica full responsibility for the training programs. A memorandum of understanding underpinned this agreement between the Ministry of Health and Wellness, Ministry of Education and Youth, and UTech Jamaica. The MOU clearly outlined that UTech Jamaica was being asked to complete the training of existing students who were already being trained by the Ministry of Health and Wellness, and to engage new cohorts to prevent a gap in the supply of nurses to the workforce. In addition, UTech would have responded to requests to support the training of dentists by taking responsibility for the Government of Jamaica's dentistry and dental auxiliary program, and public health workers by taking responsibility for the West Indies School of Public Health. In both instances, UTech was not only asked to take responsibility for the programs, but to expand them to increase the number of persons available for deployment to the health sector. Madam Speaker, UTech Jamaica has distinguished itself as a dynamic higher education institution, consistently playing its part in ensuring that the higher education landscape in Jamaica is able to respond to emerging needs in the labor market. While the university would have expanded into some non-technology areas over time, significant strides have been made in developing and implementing programs designed to ensure that the workforce is ready to access and capitalize on new and growing industries in the job market. Such strides are particularly evident in the engineering and information technology programs that the university has developed and expanded in recent years, as well as through the modification and upgrading of several programs to ensure that students are being prepared to capitalize on the growing global shared service sector. Madam Speaker, the increase in offerings to meet national needs and to increase access to tertiary education has realized a growth in UTech student population from approximately 6,000 in 1995 to 11,792 in academic year 2021-22. The increased program size and number of students necessitated over time the engagement of additional staff and change of certain operational models for the institution to serve its clients and stakeholders. In order to determine whether the staff complement that UTech started with and has expanded on was justified, an assessment of the number of programs offered by the respective faculties and the student population was undertaken. Program lists were cross-checked against data obtained from independent sources, including the University Council of Jamaica. Madam Speaker, the Ministry of Education and Youth engaged in a process of reviewing international and local standards, as well as guidelines and international trends relating to teacher-student ratios for higher education in order to evaluate the adequacy of the staff employed to the various faculties and programs. The process yielded the following information. The university offered 117 programs across 9 faculties. On average, 12,421 students were registered in the 117 programs. 909 staff served the 9 faculties with approximately 500 academic staff facilitating the delivery of the university's programs. The average ratio of academic staff to students across the university was 1 to 26, and an additional 505 staff members were employed to serve departments critical to the effective administration of the institution. Having taken the data gathered into consideration, the Ministry of Education and Youth considered that the staff complement was adequate for the university's number of programs and its student population based on the distribution of staff, academic, administrative, the levels of staff members in place were adequate. Madam Speaker, the Ministry of Education and Youth found that staff engaged to support delivery of their respective programs were suitably qualified based on international standards and criteria 6 of the UCJ accreditation manual, which requires staff to have qualifications at least 1 level above the program they are delivering. And so, Madam Speaker, the Ministry of Education and Youth obviously supports the request of UTech for approval of the expanded staffing structure. Madam Speaker, granting the institution university status would have required that UTech make changes to its staffing, its programs and facilities to satisfy accreditation requirements, which would allow it to compete locally and internationally by satisfying established international standards and guidelines for universities. Consequent on its expanded program, Madam Speaker, and the increase in the student population, UTech Jamaica also had to increase the number of technical staff engaged to manage expanding library facilities, provide technical support to labs, and maintain the expanded physical staff. Madam Speaker, this has been a long-standing issue for UTech over its history since 1995. I am extremely delighted that this government has taken the steps necessary to regularize the staff structure, giving confidence and certainty to a situation that has been allowed to meander since 1995. Madam Speaker, there's still more work to be done, but this government is committed to ensuring expanded access to tertiary education for our students. Thank you, Madam Speaker.
Madam Speaker, could the Minister indicate what costs to the taxpayers of the country the additional posts will be on the upgrading of those posts and the adjustments based on the government's compensation review.
Member, these posts, these 800...
Minister, if you would be so kind, please note the question asked by the member and allow the opposition spokesperson to speak first, and then you respond.
Madam Speaker, I welcome this statement being made by the Minister in terms of the support to UTech and facilitating the restructuring and all of that. I think it is indeed important for UTech to have the proper funding to be able to sustain the work that it is doing and as an option in terms of post-secondary education for young Jamaicans and others. I have just a couple of questions, Madam Speaker. Madam Speaker, I know that that UTASA has been seeking a meeting with the Minister to discuss a number of issues, including some of which you would have addressed just now. I wanted to know if a meeting has been had based on how the discussions of the issues that have now been resolved. It has led to frustration on the part of faculty there, affecting students, student morale, and all of what is happening. And I believe it became so problematic that there has been in the public domain quite a bit of conversation about what is happening. I'd love to get an update from the Minister, one about any meetings with UTASA, and also about whether or not there is the kind of discussion between herself as Minister, the administration, and the union to ensure that we really not just throw money at it, but that we resolve all the other issues that are important to the smooth running and effective program delivery at UTech.
She's asking to repeat the question.
Sorry. The question I was asking is what is the cost of the taking on the additional posts, the upgrading of the posts, and the restructuring to be in line with the government's compensation review? The cost to the taxpayers of those adjustments.
Thank you, Member.
All right, in terms of the cost of the additional 832, recall that in my statement, what I outlined was that since UTech came into existence, you've had these issues where they've taken on the School of Nursing, the School of Dentistry, School of Midwifery, all of that, without going through the process of the necessary approvals for these posts. So you've had persons working without having the approved posts. So this is to regularize that for those persons who exist currently and have been working at the UTech. Right. And with regards to the restructuring...
So you're saying there's no additional costs to the government for
this particular exercise.
And
right,
equally for the compensation review, bringing people up based on the compensation review. There must be. Because
so this is step one in this process, where you've had an entity that was created and told to bring on different faculties. But the process of regularizing and ensuring that they have the proper staff complement was not done. So this is a process that we just went through. That's step one. The next step would be to move on with the Ministry of Finance and the Public Service to go through the compensation review as other entities have done. And then with regards to your question, Member, the issues about the union, yes, there have been many issues at UTech. This was one of the big ones that needed to be resolved in order for us to now move on to dealing with all the others. So meetings are going to happen now with the unions.
Madam Speaker, if you just allow me to ask one question. Does this also include the retitling of the Vice President? Was this part of this phase? What that was suggested? That too has been in the public domain, which is why I asked.
No, member, this does not include that. This just deals with what exists, trying to regularize that.
House Leader. All right. More statements by ministers. At this time, I would still like to go back first to announcements to facilitate the tabling of reports that I am seeing recently. Clark. House Leader, would you like to ask for recommittal just for announcements?
I did indicate for recommittal of all the items and for you to proceed.
Those in favor? Those against? The ayes have it. Clark.
Also laid on the table of the House today are copies of the interim report of the Integrity Commission Oversight Committee on its deliberations on the annual report of the Integrity Commission 2022-2023. Certified appropriation accounts for the Ministry of Finance and the Public Service, head 20,000B, capital B for the financial year 2018-2019. Certified appropriation accounts for the Management Institute of National Development, head 16,049 recurrent for the financial year 2019-2020. Certified appropriation account for the Ministry of Finance and the Public Service for head 20,000 recurrent for the financial year 2018-2019. Certified appropriation accounts for the Ministry of Finance and the Public Service, head 20,000A, capital A, for the financial year 2018-2019. And the certified appropriation account for head 4,000, Ministry of Labor and Social Security for the financial year 2009 to 2010, and annual report 2015-2016 for the National Works Agency. And last but not least, performance audit, managing the main road network, from the Auditor General's Department.
So for the abundance of transparency and clarity, all reports sitting for executive agencies have been laid. The ones for public bodies I have returned, 2 of which are no longer operational. If you would like to know the names of them, I am happy to do so. There is one report that I am in abeyance because I know the Senate laid. I recall that Integrity Commission had sent back for it, so I'm really not so sure where this report is at. I would like to do some further checks to see if anything came back. It came back. Because that, I'm not sure.
Madam Speaker, it came because we dealt with it this morning. Yes, it's one of the 7 that we dealt with this morning. Yes. Yes.
So if it came back, in which case I would want to table this report as well. So before we move on to the next item, Let me just read the list of those reports received, not yet tabled, for the benefit of the House. Montego Beach 1975 Limited, annual report for 2014-15. FinSac Limited, annual report for 2022. Financial Institution Service Limited, annual report for 2022. And Factories Corporation of Jamaica, annual report for 2016. These are public bodies and would be treated as such until further notified. As it relates to the Integrity Commission report on, let me say, AAJ and NMIAL.
Madam Speaker, may I give a little guidance on that? Madam Speaker, the report having been tabled in the upper house is deemed to be tabled, and it was referred to my committee, and we dealt with it today, a report of which I will give a little later on. May it please you, Madam Speaker.
Madam Speaker, just clarity. The four you named are annual reports. They're not reports from either the Auditor General or the Integrity Commission. They're from Integrity? No, they're just annual reports. Those are just annual reports.
They're just annual audit reports. This is an extra.
Yeah. So just
Madam
for
Speaker,
clarity,
just for clarity, the reports which you tabled a while ago would in the normal course of events be read by the clerk of the House in terms of a report. So for good order, yes, an announcement.
Absolutely, which is why I recommitted announcements. I would have used the opportunity during statement by Minister to go through, as previously indicated, all the reports that are currently in or at the Register of the Parliament. The only one, as I said, I was a bit unsure about is the report on NROC, because on First Rock, yes, sorry, because I was not sure if it was tabled already. So the House Leader is providing clarification. It has already been so tabled. So I will move on to the next item, which is bills brought from the Senate, petitions, papers, reports from committees.
Madam Speaker, I beg to lay on the table of the House a copy of the interim report of the Integrity Commission Oversight Committee on its deliberations on the annual report of the Integrity Commission 2022 to 23.
Notices of motions given orally.
Madam Speaker, I beg to give notice that at the next meeting of the House, I will move to introduce and have read a first time a bill short entitled The Constitution Amendment of Sections 96.1 and 121.1 Act 2023. Madam Speaker, I further beg to give notice that at the latest stage today, I will move for the suspension of the standing orders to enable me to take first reading and second reading of the bill, and also for me to take it through all its concluding stages.
Madam Speaker, I beg to give notice that at the next meeting of the House, I'll move to introduce and have read a first time a bill shortly entitled the Financial Administration and Audit Amendment Number 2 Act 2023.
Next item. Nothing else.
At a later point, he will relate. Madam Speaker, I beg to give notice that at the next meeting of the House, I will move the following motion. Be it resolved that the interim report of the Integrity Commission Oversight Committee in its deliberations on the annual report of the Integrity Commission 2022-23, which was laid on the table of the House on the 25th day of July 2023, be approved, Madam Speaker. And Madam Speaker, at a later stage today, I will move for the suspension of the standing order to enable me to take this motion.
Thank you, House Leader. Questions and answers to questions?
Madam Speaker, this is the third time I'm rising on this issue. There are 6 questions from members on this side that are overdue, some 3 months, some 4 months. I've asked repeatedly for questions to be answered in a timely fashion. The Parliament allows 21 days, and routinely we have breached that with no response from the House Leader or the persons who are to answer the questions. We are going on recess today, and so these are questions that may not be answered until September. It's really not an acceptable way for the business of the House to be run.
House Leader.
Madam Speaker, the member is in his right to ask the appropriate or make the inquiry about the answers to his questions, and it's quite correct. Madam Speaker, but it is unfair for the member to say that he has not heard any responses when he makes inquiries, because on the last occasion when the inquiry was made, we did indicate that that they will be answered, and Madam Speaker, they in fact will be answered, and the member knows they will be answered. The fact of the business of the House over the last few weeks, Madam Speaker, and a number of incidents and activities that have overtaken that. But the member will have his questions answered, and there's no question about it. It will be answered. It will be answered, Madam Speaker.
Motions that may be made at the commencement of public business requiring notice, motions relating to the sitting of the House, motions for leave to introduce bills. Presentation of bills without leave of the House first obtained.
Madam Speaker, I now move for the suspension of the standing orders to enable me to take the first reading of the bill, notice of which I gave earlier.
Those in favor?
Madam Speaker, I just want to speak on that motion.
Those against?
Before you put the motion, I'd like to speak on it. Madam Speaker, the bill which the Minister is giving notice of reading on is a constitutional amendment. We are totally against the way that the government is proceeding with this matter, where they're seeking to amend the Constitution by legislation that is being tabled today without any prior consultation, either with the opposition or indeed with the Constitutional Reform Committee on this matter. And not only are they tabling it today, but my understanding, based on one or more versions of the notices of this day's proceedings, because we had several notices flying around this morning, the last of which excluded this particular bill from the notice. But nevertheless, we're seeing it being taken today. But the notice that included a reference to it, which was not the last one, indicated it would be not only tabled but taken today through its stages. Madam Speaker, this concerns a provision dealing with the Director of Public Prosecutions and the Auditor General, and to do with the tenure of the holders of those constitutional offices. We are strongly against an attempt to address a desire to have an incumbent individual holder of either of those offices have their tenure extended by a constitutional amendment, which is going to be a permanent amendment. That is not the way in which these things should be dealt with. The appointment of the DPP and the decision to extend the tenure of the DPP's office, which the Constitution says has to be agreed before the person's 60th birthday, those are matters on which the government is obliged to consult with the opposition on. Here we are having legislation tabled to amend the Constitution of the country with no prior consultation or notice other than what came today. It is irregular, it is improper, it is bad governance, and we intend to vote against it We intend to vote against it for those reasons, and we also will be taking legal advice as to whether what is happening here is within the Constitution. And if our advice is that it is not, we shall take the matter to court. And we will also be reconsidering our participation on the Constitutional Reform Committee, because that committee has been set up to address constitutional reform. It is being bypassed by this legislation being brought here for whatever reasons and being rushed through this Parliament when there is a process of constitutional reform underway, and where that process has not had the opportunity to even consider this matter. It's a very sad state of affairs, and we want to register our strongest possible protest against what is happening. Thank you, Madam Speaker.
Thank you, Opposition Leader.
Madam Speaker, I now move to introduce and have read the first time a bill shortly entitled the Constitution Amendment of Sections 96(1) and 121 Act 2023.
The Opposition Leader has called for a divide. Well, you can still, it is...
Is it right?
Clarification is sought on this, because the matter is not a motion that has been debated for which a decision is to be taken in terms
it's just going to public business.
Exactly. It's just a matter here of a presentation of a bill. It is a presentation of bill, a leave for first granted by the House. For the first time. So, Madam Speaker, I think that the member can have the benefit of a vote on a divide at a later point today. He can have that benefit.
Opposition Leader, could you please turn off your mic? Minister Shaw, could you please do the same?
Sorry?
Could you please turn your mic off? House Leader, Opposition Leader, Minister, the question is that the bill be read a first time, notice of which he gave earlier. You, as the House Leader indicated, will be able to vote at a later stage on a divide. However, I think I can rightfully appreciate the response of the members in the House in asking those in favor. No, I'm not hearing the members. I'm not going to have a divide because at a later stage you would be able to divide. Or you want to divide now? And you want to divide again? So the question is that the bill were read. Why would we have a divide on the bill being read? You want to divide?
Madam Speaker, Madam Speaker,
hold on, Opposition Leader, hold on. I hear you asking for divide. Those in favor, could you sit a moment, please, Opposition Leader? You may have a point of clarification.
Yeah, Madam Speaker, the member, having at the first instance asked to the standing orders to enable him to read the bill for the first time, those in favor, and we all said divide. So, yeah. Which is an unprecedented arrangement, but it is acceptable. Yes.
Madam Speaker,
Right.
We are disagreeing with the process.
Let me move ahead instead of arguing about the process. It is very unusual to call for divide on the reading of the first reading of the bill, but since the question has been asked, I am happy to spend all day and night here with all of you. Could you read, Clark, as it relates to the divide on this vote?
Mr. Bartlett.
Just to ensure that all the members in the House who were not paying attention, here
Madam Speaker, for good order.
I'm going down the road.
The divide is in relation to the first reading of the bill. So the obvious response is no. It's guidance. It's guidance. So, no.
So House Leader, House Leader, as I said, it is most unusual. However, I am asking the question.
So those in favor?
Those in favor.
All right. So divide.
No, hold on. Those in favor. No, that's not my statement. Please allow me to finish. Those in favor of having, no. Please allow the speaker to complete the question. I am making a specific statement because of an unusual and unprecedented request. The request is to have a divide on the first reading of the bill. And my statement to the House is, those in favor of having a divide on the reading of the bill.
Madam Speaker, it's very clear. The vote members would be in the normal way that divides are taken. Right. And for guidance, the proposers would be yes and no. Exactly.
So allow me to finish the question. You have asked for a divide in respect of the reading of the first bill. My question to the House, those who vote yes to preventing or not having the reading of the bill.
Madam Speaker.
The motion is for first reading of the bill.
Madam Speaker, it's a simple, they're dividing.
Yes or no?
They're dividing on the first reading. On the first reading, so the proposers of the bill, which is the government side, the response is aye, yes.
I'm trying out of an abundance of caution not to just say aye, yes.
Yes.
I would want to hear those persons who believe that they wish to proceed with the first reading of the bill say yes. Those who do not want to proceed say no, instead of the regular aye and nay. Those who are of the view that your statement to the House is yes, let us hear your statement. Call the names, Miss.
Mr. Bartlett. Mr. Bartlett.
Minister Bartlett.
Mr. Brown. Dr. Brownberg.
No, hold on, Member Brownberg. Members, unless you would like to spend the rest of the night here with the speaker today, I would like you to pay attention. Your names are going to be individually called, and you're being asked to say yes or no. I do not want to hear a sound in the House so that you can hear your name being called. I'm hearing names being called, and we're looking around and wondering if persons are hearing. So please listen for your name. Go ahead, Clark.
Dr. Brownberg. Dr. Chang. Dr. Charles. Mr. Charles. Mr. Charles. Mr. Chin. Mr. Chuck. Mr. Clark. Dr. Clark. Mr. Cousins.
No.
Ms. Crawford, Mrs. Cuthbert Flynn, Ms. Daly, Mr. Davis, Ms. Davis, Dr. Dunn, Mr. Golding, Mr. Graham, Ms. Grange, Mr. Green, Dr. Guy, Ms. Hamilton, Ms. Hannah, Mr. Henriquez, Mr. Henry, Mr. Holness, Mr. Hutchinson, Mr. Holness, yes. Mr. Hilton.
Prime Minister and the member Minister Morgan just walking in. The vote is yes or no.
Mr. Hilton, Mr. Jackson, Mr. Lawrence, Miss Lee, Mrs. Malawi Fort, Mr. Main, Mr. McKenzie, Mr. Miller, Miss Morrison, Mr. Montague, Mr. Morgan, I'd said it. Mrs. Nita Garvey, Mrs. Nita Garvey, absent. Mr. Paulwell, Mr. Phillips, Dr. Phillips, Mr. Robertson, Mr. Robinson, Mr. Samuda, Mr. Shaw, Mr. Siblist, Mr. Slowly, Miss Smith, Mr. Terry Long, Dr. Tufton, Mrs. Vaz, Mr. Vaz, Mr. Warmington, Dr. Wheatley, Mr. Williams, Mrs. Williams, Mr. Wilson, Mr. Witter, Mr. Wright, Dr. Chang,
Members, the question has resulted in 8 noes and 38 yeses.
A bill shortly entitled The Constitution Amendment of Section 96(1) and 121(1) Act 2023, read a first time.
Madam Speaker, I beg to give notice of second reading of the bill.
Madam Speaker, the Minister of Finance will have the second reading shortly. Madam Speaker, I beg to move that you proceed with public business so as to allow for the constitutional amendment measure, which is a priority measure, to be taken at this time, followed after by the Child Care and Protection Act and the Bail Act. May it please you, Madam Speaker.
Minister Chalk.
Thank you very
Minister
much,
of Justice.
Madam Speaker, I now move for the suspension of the standing orders to enable me to take second reading of the bill, notice of which I gave earlier, and also for me to take it through all its concluding stages.
Those in favor? Aye. Those against? The ayes have it.
Madam Speaker, the Constitution of Jamaica establishes a retirement age of 60 for the position of the Auditor General and the Director of Public Prosecutions via Sections 121(1) and Sections 96(1). Madam Speaker, the Pensions Public Service Act, which was promulgated in 2017, sought to, among other things, gradually increase the retirement age of public officers to 65 years. The bill before this Honourable House, Madam Speaker, reflects a proposal previously considered by Cabinet during the deliberations on the Pensions Bill in 2017. It was the intention of the government to amend the Constitution to give effect to the change in the age of retirement for officers so as to extend the increase in the retirement age to both the Auditor General and the Director of Public Prosecutions. Madam Speaker, as is evident, this was due mainly to the fact that the constitutionally established ceiling for the age of retirement for the Auditor General and the Director of Public Prosecutions is actually 5 years shorter in duration when compared to the upper limit set in the Pensions Public Service Act for public officer in the civil service. Madam Speaker, the proposed amendment to the Constitution will allow for the expansion of the term of service from 60 to 65 years, thereby addressing the inconsistency that currently exists between the two pieces of legislation and, by extension, creating a more level playing field for all. Madam Speaker, I will now highlight the main features of the bill. Constitution Amendment, Sections 96(1) and 121(1), 2023. Clause 1, Madam Speaker, treats with a short title and construction. Madam Speaker, Clause 2 amends Section 96(1) of the Constitution by removing the words 60 years and substituting instead the words 65 years. Additionally, the clause deletes the words not exceeding 65 years in paragraph B of Section 96(1) and substitute the words not exceeding 70 years. These amendments raise the age of retirement to 65 years and allow the Governor General in appropriate cases to permit an extension up to 70 years. The clause goes on to allow a sitting director of public prosecutions at the date of the commencement of this amendment to the Constitution to elect in writing to the Governor General to retire at any time after attaining the age of 60 years. Clause 3, Madam Speaker, amends Section 121(1) of the Constitution by removing the word 60 years and substituting instead the words 65 years. Additionally, the clause deletes the words not exceeding 65 years in paragraph B of Section 121(1) and substitute the words not exceeding 70 years. The clause, Madam Speaker, goes on to allow a sitting Auditor General at the date of the commencement of this amendment to the Constitution to elect in writing to the Governor General to retire at any time after attaining the age of 60 years. Madam Speaker, this ends the clause-by-clause summary of the bill before you. I now, Madam Speaker, note that the framers, Madam Speaker, of the Constitution anticipated that the age of retirement can change so that the provisions were neither entrenched in 2017, and it can be dealt with today.
I will go with the opposition leader first, and then Cousins.
Madam Speaker, as I've already indicated on the motion for first reading of the bill, we object strongly to what is happening here today with this constitutional amendment, which has been brought here without prior notice to us, without any consultation with us, concerning provisions to do with the appointment or extension of tenure of the Director of Public Prosecutions and the Auditor General. In relation to those provisions, consultation with the Leader of the Opposition is required, whether for appointment or for extension. Yet we are amending those provisions without any prior consultation. Furthermore, the Constitutional Reform Committee, which is dealing with the reform of the Constitution, has not been seized with this matter. It has not been discussed there. They have been bypassed with this particular amendment. The minister is indicating that this is pursuant to the amendment to the pensions legislation of 2017. But the first attempt to extend the tenure of the DPP arose in 2019. And that extension was for 3 years. We objected, my predecessor, objected strongly in writing with substantive reasons why we did not support that extension then. Nevertheless, the government has chosen to proceed in this way, to seek to amend the Constitution of Jamaica by bringing a bill, tabling it on the same day that they intend to debate it and pass it in the House. It is bad governance, it is disrespectful to the opposition, it is disrespectful to the Constitutional Reform Committee, and it is a dark day for our country that we would proceed in this way on a matter of constitutional amendment. Constitutional amendments are not to be addressed in this manner. And furthermore, to seek to amend the Constitution so as to affect the existing tenure of incumbent holders of office is also controversial and I think improper. It is one thing to amend the Constitution to deal with future office holders, but you're dealing with incumbent office holders and extending their tenure in office. And we object to the procedure that is being followed, and as I've said, we'll be taking legal advice on it to see whether or not we can challenge it in court based on the procedure being followed and the overall surrounding circumstances that have led the government to proceed in this way. Furthermore, Madam Speaker, the context in which this is happening is also disturbing. We are told that there are pending investigations by the Integrity Commission in relation to parliamentarians for illicit enrichment. We do not know the facts around that, other than that's referred to in the annual report of the Integrity Commission, which has, after some delay, been tabled. and made public. The Director of Corruption Prosecutions, who would have charge of those proceedings, is subject to the supervening authority of the DPP under the Constitution. The rush to make these amendments happen now in that context is also, to my mind, something which requires some explanation. And I'm extremely uncomfortable with the way the government is proceeding in this matter. And the howls of the government benches as I seek to ram through this amendment to the Constitution of the country further reinforces my concerns. As I have said, Madam Speaker, this is a dark day for Jamaica. I'm very, very disappointed in the government that they are proceeding in this way in relation to a matter of constitutional importance, affecting two constitutional office holders. The appointment or extension of their tenures is something for which consultation is required. Yet they are proceeding here with no consultation, and they want to ram it through on the last day of the current session of Parliament before the summer recess. Madam Speaker, we will not be supporting this bill.
Next we will take the member from Clarendon Southwest.
Thank you, Madam Speaker. I'll begin by also agreeing with the Leader of Opposition as it relates to my objection, not to the fact that the Constitution, by way of Section 49(4), does provide for an amendment to Section 96(1), because if you look at 49(4), it speaks to 96(2), 3, 4, 5, 6, 7. So obviously 96(1) was not contemplated as an entrenched provision. But I have to disagree with the approach that is being taken. And provisions that require consultation, for example, with the Leader of Opposition, if amendments or alterations are to be made, similarly, out of due respect to the office of the Leader of Opposition, and in the spirit of the Constitution, that consultations ought to have been had. So now hearing that no consultation was in place, in fact, I believe is totally improper. If you look at the context of how we are approaching this thing, so are you saying, Minister, that any government can at any time reduce that age from 60, that is in Section 96(1), to 50 or 45 to suit their cause? You see the danger of that? The danger of it is that no, Section 96(1) provides for alteration. You can lower the age if you want to. And that is the fact. And I'm saying that that is absurd and it is dangerous. Because what may obtain is any government at any time coming to this Parliament, amending a constitutional provision by way of a simple majority to suit its agenda. So that clearly must have been an oversight. The most important point is that we are embarking now on a process of constitutional reform. And having embarked on that process, we ought to have considered this provision in that entire process. Put it to the people to find out if the people of Jamaica have an interest in extending the office holder to 70 years. Because 70 years are really going now, you know. It's not 65 years, you know. It's really 70 years. Because the amendment that is being proposed is for 70 years. Now, the danger of it, you know, is that September 21st, I believe, will make it 3 years since the last extension, which would mean as at the 21st of September, a few months from now, the current holder of the office of DPP. No, this is reality. The current holder of the office of the DPP's tenure would come to an end. The Constitution provided for consultation. 3 years was granted. She could have gotten 5 years. 3 years was granted for some purpose. I don't know. I was not here at the time. But the 3 years must have been granted on some consideration. Now, Minister, the question is this. Has the current holder of the office of DPP, for example, applied or sent any request to you for an extension? Because I don't know what would have necessitated us coming here to make this amendment. Is it that there's nobody at the office of the DPP? We have 2 King's Counsel, 1 director, 1 senior deputy director, King's Counsels. Is it that the senior deputy director is not competent to take over the role of the Office of Director of Public Prosecutions? Is it that we are having a challenge with the process? Because the reality is that, having contemplated that September, the tenure would come to an end, we would have perhaps embarked on a process by now to select a replacement. Is it that no process has been embarked upon to select a replacement as yet? Because we're in July, August, September. So we should have been far down the wicket where a replacement is being contemplated. So I find it very curious we're coming here today to do this. Minister, you know that I am a proponent of the extension of age limits for members of the judiciary. You remember when we were here last year, I believe, when the Court of Appeal President's tenure was coming to an end. And I stood here in Parliament and advocated for it to be extended because it's just a process. And that's why I'm saying the process is my problem. No consultation, no. So, Minister, you know that I am an advocate for that. As a member of the legal profession, I know that attorneys who attain the age of 60, going 70, 80, many are still sharp, perhaps in the prime. So nothing is wrong with that. The procedure and the process, justice must not only be done, it must be seen to be done. And something is rotten in this entire approach. No, Tony, I'm not finished. Oh. My final point, Minister, is we hear the prosecutors, them crying. We hear the cries of the prosecutors. The salary that they're receiving is not sufficient. I know that a Crown Counsel, what they make is little to nothing. Because I've personally been impacted by that. My spouse was a Crown Counsel up to 2 years ago.
Member?
I am debating.
No, you're not debating.
I'm saying that
member Cousins.
The Office of the Director of Public Prosecution, rather than focus on this, we're focusing on the wrong things. It's a misplaced priority situation. Focus on trying to give the prosecutors a decent salary.
Member Cousins, could you stick to the issue being debated?
I'm at liberty when I'm debating. You can't restrict me. It's not a statement from a minister. It's a debate. I am at liberty. I am sure. So, Minister, in closing, I'm saying that the focus should be on the working conditions. You met with them recently, I'm sure. Oh, so you know the issues. Focus on that. What we're focusing on now is not the real issue. The bigger issue is ensuring that our prosecutors in this country are comfortable and get compensation and benefits that they deserve. There are significant risk in this country. Every day they go out there to prosecute criminals. And you're telling me that you cannot give them a decent and affordable living condition? That is totally unacceptable. But, Minister, I said the approach you're taking now, I have a lot of respect for you. You know that. The approach we're taking now is totally improper. And without consultation, I have to vote against it. Thank you.
Thanks. Next, we will take the member from St. Andrew South Eastern.
Madam Speaker, I have 3 points I want to make. My first point relates to process, and I want to repeat what my colleagues have said about process. This is a constitutional amendment which goes to the heart of 2 of the most critical offices in the country. in addition to the lack of consultation with the opposition leader, there is need for consultation more broadly within the society to determine the appropriateness of these amendments. So I want to give you an example with the Auditor General. Across the world, including the Commonwealth, countries are moving to fixed terms for their Auditor Generals, not terms where people serve until a particular age. Within the Commonwealth, you have the United Kingdom, South Africa, Australia, within Europe, within Asia. Fixed terms, whether it is 7 years, 10 years, 12 years. The benefit of a fixed term is that the person knows that at the end of a period, regardless of decisions they may take, and in these two cases, these two office holders deal with very sensitive matters related to public officials. And the fixed term gives them a sense of security. So the first issue on consultation, we are moving against the grain in terms of what most of the world is doing in moving to fixed terms. The second issue I want to raise in respect to the DPP, it is very important that both the perception and the reality of independence of that office and impartiality be maintained. Absolutely. It cannot be right for the executive arm of the government to be rushing through Parliament with no notice an extension of the office holder of the DPP. You are compromising the independence of the office by doing so. And as such, the perception will arise that the incumbent, who is the beneficiary of this extension, will be somehow beholden to the executive. Right. It is wrong. It is absolutely wrong. So on the issue of process, the process is wrong. There has been no consultation with the opposition or with anybody in civil society or with the wider society on two critical amendments. Secondly, we are going against the grain of good governance, where more countries are moving to fixed terms for holders of this office. And third, we are compromising the independence and impartiality of the office of DPP by doing it in this manner. And as my two colleagues said, I will vote against this amendment.
The member from St. Andrew East Western.
Thank you, Madam Speaker. Madam Speaker, I'm very concerned. And the reason is because we are engaged in a process of constitutional reform, of which I'm a member of that committee. That committee so far has worked in harmony and on a basis of consensus. That's a declared principle in which we've all accepted and abided by and have conducted our discussions. My rising today is not to discuss the committee and what has been discussed in the committee, but to say that to have this important constitutional amendment to two critical offices and not giving the committee an opportunity to even discuss this matter. Tomorrow, we have already agreed that we have consultations, town hall consultations with the people. I must say that to date, this issue has not come up in any of the town hall discussion. But having come up and been placed on the table of Parliament, I would have, for example, liked to see and to hear the views of these persons with whom we are consulting. So to have this submitted today, tabled today, and to be taken all in one go without any opportunity for us tomorrow, and I'm sure tomorrow, if we proceed with those town hall meetings, this question is going to come up. And the people would have been deprived of an opportunity to express themselves on this very important issue. Prime Minister, I believe, I want to urge you to, it is not too late to consider this is going to have implications for the very important process that you've put in train to consult the people of this country on the reform of the Constitution. This is a fundamental issue, and it affects and will, if it goes forward, undermine that process that we have invested time and effort, significant time and effort, in trying to bring to a closure. And I am concerned about it, deeply concerned about approaching it in this way. Thank you, Madam.
The member from St. Catherine Eastern.
Thank you very much, Madam Speaker. Minister, I'm going to ask you if you could tell me what is the rate of attrition in the DDP office. I am told that it is very, very high. And I'm wondering if they feel that there is no room for them to be promoted. Because, Minister, we have to be very careful. By even the extension of age that we are talking about, they are going to now believe that there is no room at all for them, for their upward mobility. And therefore, I believe we need to look carefully on this, because don't care how good the persons are, we have a better each time. So we need to refresh that office and do it now.
Minister Chuck.
Madam Speaker, I note the comments of the members. I now ask that the bill be read a second time.
The question posed by the minister is that the bill be read a second time. Those in favor? Aye. Those against? The ayes have it.
A bill entitled An Act to Amend the Constitution of Jamaica to provide for an increase in the retirement age of the Director of Public Prosecutions and the Auditor General, and for connected matters, read a second time.
The House will now resolve itself into a committee of the whole House to consider the bill, clause by clause.
Madam Speaker, you could proceed. Madam Chairman, you could proceed. No, go through.
Minister, I now put to the House clause 1 of the bill. Those in favor?
Aye.
Those against? The ayes have it.
At the end.
If you call for divide again, I will then take the opportunity, because during the discussions I researched the decision made to allow a divide on the first reading of the bill, which was an incorrect decision to have made. And I will ensure that the House is seized of the section of the standing order, Section 45, as it relates to collection of votes, requires that the Speaker or Chairman allow the conclusion of a debate on any question before we are allowed to raise our voices in respect of ayes and nays, and continues into Section 46. So I am going to
continue, Chairman.
I put clause 2. Those in favor?
Aye.
Those against? I put clause 3. Those in favor?
Aye.
Those against? I put the title and enacting clause. Those in favor?
Aye.
Those against? The question is that I do report the bill as having passed committee stage without amendments. Those in favor?
Aye.
Those against? The ayes have it. I do report the bill as having passed committee stage without amendments. Minister?
Madam Speaker, I now ask that the bill be read a third time.
Those in favor? Those against? Clerk, we will take the divide that they have called for. Please read alphabetically and have persons vote individually as it relates to accepting or voting against the bill.
Mr. Bartlett? Mr. Brown? Dr. Brown-Burke? Dr. Chang? Dr. Charles? Mr. Charles? Mr. Chin? Mr. Chuck? Mr. Clark? Dr. Clark? Mr. Cousins?
No.
Ms. Crawford?
No, 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 no.
Mrs. Cuthbert Flynn? Ms. Daly? Mr. Davis? Ms. Davis? Dr. Dunn? Mr. Golding? Mr. Graham? Ms. Grange? Mr. Green? Dr. Guy? Ms. Hamilton? Ms. Hannah? Mr. Henriquez? Mr. Henry? Mr. Holness? Mrs. Hol... Oh, no. Mr. Hutchinson? Mr. Hutchinson? Mr. Ilton? Mr. Jackson? Mr. Lawrence? Ms. Lee? Mrs. Malawu Fort? Mr. Main? Mr. McKenzie? Mr. Miller? Ms. Morrison? Mr. Montague? Mr. Morgan? Mrs. Nita Garvey? Mr. Paulwell? Mr. Phillips? Dr. Phillips? Mr. Robertson? Mr. Robinson? Mr. Samuda? Mr. Shaw? Mr. Siblist? Mr. Slowly? Ms. Smith? Mr. Terrelong? Dr. Tufton? Mrs. Vaz? Mr. Vaz? Mr. Warmington? Dr. Wheatley? Mr. Williams? Mrs. Williams? Mr. Wilson? Mr. Witter? Mr. Wright?
I do report that the votes are 39 yeas and 8 nays.
A bill entitled An Act to Amend the Constitution of Jamaica to provide for an increase in the retirement age of the Director of Public Prosecutions and the Auditor General, and for connected matters, read a third time and passed.
House Leader.
Madam Speaker, we continue public business, and the next item will be the Child Protection Act bill, and the Speaker will be the Minister of Education and Youth. May it please you, Madam Speaker.
Honourable Fayval Williams, Minister of Education and Youth.
Thank you, Madam Speaker. Madam Speaker, the debate was started at an earlier date, and so if it pleases you, Madam Speaker, I would like for you to call on the contribution from other members. Thank you.
Closing now? Closing now? Come on, this mic.
Opposition Leader.
Thank you, Madam Speaker. Madam Speaker, I want to acknowledge that the Minister did permit some time for a review of this bill after she opened the debate, when we had requested an opportunity to have some time to look at it. I believe at the time she wasn't keen on that, but good sense prevailed, and I thank her for this opportunity to speak to it. Madam Speaker, the main purpose of this legislation, I believe, is to bring an end to the current state of affairs, which has existed for the life of the Child Care and Protection Act, which allows the court to make a correctional order in respect of children who have exhibited uncontrollable behavior when they are brought before the court, either by their parents or guardian, or perhaps some other appropriate officer. The result of this over the years has been that children have ended up in correctional institutions when they have committed no offense. Uncontrollable behavior is on a spectrum ranging from relatively mild acting out in an adolescent way through to more serious forms of behavior, but falling short of actual criminal behavior. Because if the child commits a criminal offense, then that is a matter which is dealt with through the criminal justice process in relation to children. So for a long time, Jamaica has been criticized justifiably by international bodies, in particular the UN, that is concerned about the welfare of children, and equally importantly, if not more importantly, within Jamaica itself, stakeholders have said for many years that we need to adjust our law so that this is no longer a possibility. And this recommendation was made, I believe, in the Joint Select Committee report that had reviewed the Sexual Offences Act, but also looked at some other laws relating to women and children and how the criminal law interfaces with them, including the Child Care and Protection Act. So, Clause 6 of this bill, which is the clause which repeals Section 24 of the Child Care and Protection Act, is to be supported. Section 24 of the Act, the existing Act, reads, "The parent or guardian of a child may bring the child before a juvenile court," which I believe is now the Children's Court. "And where such parent or guardian proves to the court that he is unable to control the child, the court may make an order in respect of that child if satisfied that it's expedient so to deal with the child and that the parent or guardian understands the results which will follow from and consents to the making of the order." And then subsection 2 of section 24 says, "An order under subsection 1 may be a correctional order." And there are some other alternatives as well. So that section is being repealed by clause 6 of the bill. And we support that. It is obviously wrong in principle that a child may be subject to a correctional order where that child has not committed a criminal offense. And it has been a provision which has resulted in children having to experience the deprivations of being incarcerated and have suffered as a result of that experience. Children need care and attention of a different form, which is directed at their holistic development and which is sympathetic to their needs and is tailored to suit those needs. So I support clause 6. Where I have a difficulty is with other aspects of this bill, which introduce a new approach to dealing with children who have behavioral challenges. And I do not support the approach being taken in the bill because it is inconsistent with international best practice as to how the legal system and the system of managing children and the issues faced by children ought to be dealt with in the law. So, for example, the UN and UNICEF in particular has shared their views on this aspect of the bill and have indicated that they are very concerned about how the bill is dealing with children who have behavioral challenges. And I'm looking for the quote which I had found, which addresses the kind of principle that ought to prevail in accordance with international best practice, and which the bill isn't following. So, when you look at the clause 2 of the bill that amends the definition section in the Principal Act, there's an extensive new section with a definition of behavioral challenges in relation to a child. And it lists an inclusive list, and doesn't purport to be a complete list of what amounts to behavioral challenges. There's also, I see some amendments are being tabled here. I haven't been able to review these amendments, and I'm sure the Minister will take us through them when she closes the debate. I won't attempt to go through them now because, as I said, I haven't read them, and I see there's some quite lengthy provisions. But included in the list of what amounts to behavioral challenges are constant truancy from school, running away from home, staying out late without reasonable explanation, engaging in disruptive activities at school, exhibiting a low frustration threshold by displays of irritability or emotional outbursts or temper tantrums, procrastination, or hyperactivity. Use or possession of tobacco or tobacco products. So, smoking cigarettes as a teenager is an example of a behavioral challenge. Consumption of alcohol. Madam Speaker, what the bill then does is say that certain persons may bring a child before the children's court. And one of the grounds on which a child can be brought is that they're in need of care and protection on the ground that the child is a child with behavioral challenges. So what this now introduces into our law is a jurisdiction by which a parent, a constable, an authorized person can bring a child before the court who is exhibiting behavioral challenges. And then the court can make various forms of order. Now, I have a problem with that. First of all, I would say that acting out, risk-taking, challenging authority figures, skipping school, exhibiting rebellious behavior is really a normal part of growing up for many, many children. Many children. Indeed, I'm sure many of us in here would have done some of that in our time. Bringing these children before the courts is counterproductive because it can actually increase the chances that the young person will go beyond exhibiting behavioral challenges and end up offending. Children are highly susceptible to stigmatization and are more likely to go on to offend when they're labeled as delinquent or pre-delinquent, or feel rejected by or disconnected from their families, or their schools, or their communities. So by bringing a new procedure into our law to deal with behavioral challenges, which is a court-based procedure, is fundamentally at odds with what is best practice internationally for how children are to be dealt with when they are showing signs of behavioral issues. What is required when a child exhibits behavior suggesting they need an intervention is an individualized assessment. It can't really be reduced to a list. And what really should happen in that instance is that the CPFSA, we used to be the Child Development Agency, I think it's now the Children and Child Protection and Family Services Agency. They ought to be the entity that triages how children exhibiting these issues are addressed. There should be a mechanism built within the CPFSA for assessing the child, the risks, strengths, and needs of the child, and what voluntary interventions should be provided. And indeed, court-based or court-ordered interventions should only be a last resort after efforts have been made and as should be required by law for the child care system to deal with this child's problems through voluntary support. And if there is clear evidence that the child now presents a significant risk of harm to the child or to others, then the court can be brought into the matter, but not before. The definition also fails to distinguish between children with behavioral challenges on the one hand and children who are in conflict with the law. And children who are in conflict with the law and commit offenses are already addressed under a separate part of the Act, Part 4, and are subject to court orders under Section 676, which is a different regime entirely. So the Child Care and Protection Act has a legal regime for dealing with child offenders, and this is not touching on that. But this bill, as presented, is dealing with a whole new cohort, children with behavioral challenges, and is doing so in a way that does not accord with international best practice, and which brings them into court where they face stigmatization. And all of that, instead of building into the child protection system and the institutions within that system a way of triaging those cases outside of the court system. So, Madam Speaker, I'm very concerned when we are amending the Child Care and Protection Act in this fundamental way, and they are doing so in a way that does not enjoy the support of UNICEF, which is the UN body responsible for children, and which is introducing into the mechanism for dealing with children who may have behavioral challenges, which, as I said, are on a wide spectrum, a procedure that brings them into court and makes the court the mechanism for addressing those cases, and where a variety of different orders can be made by a judge in relation to that child. That is not what children need when they are not committing offenses, but are acting out or otherwise displaying behavioral challenges. So, Madam Speaker, I regret that this is the route that this legislation is taking. I would have recommended that the bill be withdrawn, or if passed, we pass Clause 6 and eliminate the aberration that exists in our law now, which is for correctional orders to be made for children who are in need of care and protection and who are deemed uncontrollable. Clause 6 addresses that, and I'm fully in support. But it's the rest of the new mechanism that has been created for dealing with children with behavioral challenges, which I have a substantial objection and concern about. And I am also aware that the institutional arrangements that would support the kind of orders that this bill contemplates are themselves lacking, because we do not yet have sufficient institutional support to deal with non-residential therapeutic orders by the court and residential therapeutic orders and so on. We have a paucity of institutional capacity for dealing with that. So the court is going to be faced with a reality out there which is not consistent with the law that is being imposed or passed today. And I think that is to be avoided. We should wheel and come again. We should pass the act in relation to Clause 6, eliminate correctional orders in relation to children who are not offenders, and build into the child protection mechanism a triage system for dealing with behavioral challenges, which is holistic, which caters to the individual needs of the individual child, which avoids the stigmatization of bringing them into the legal system and the court system, and helps them to be rehabilitated. Even in relation to child offenders, children who are in conflict with the law, we have adopted the child diversion process. And the child diversion policy was developed when I was Minister of Justice, and the legislation was eventually passed under the current minister. And I think it needs to be supported further because it recognizes that children are best dealt with in ways other than through the court system. And there are parish committees set up to seek holistic solutions to the needs of individual children who have come into conflict with the law. That's a good thing. But here we are now dealing with a whole cohort of children, typically adolescents, I would say, but not exclusively so, who are exhibiting behavioral challenges in this very wide array of behaviors, which is not complete, but which, even though it's incomplete, includes many things which really do not warrant putting the child through a court-based system of triage to make a court order in that. And when the court order is breached by that child is in contempt of court, which is a very serious matter as well. So you're dealing with the coercive system of the court in enforcing orders against children and adolescents who are not themselves offenders. And I again have a big issue with that. That to me is the wrong approach. So, Madam Speaker and Madam Minister, I'm happy with Clause 6, but I'm not at all happy with the rest of the bill and the approach being taken to dealing with our children who are not offenders, but are acting in a way that adolescents and some other children often do, which is present behavioral challenges, which if properly addressed in a holistic way, in a sympathetic way, without stigmatizing them, can be remedied, and some of them may become parliamentarians. Some of them may become
Look at Darren.
Local government practitioners.
Where's Darren?
Yes, that's true actually. I can think of one particular individual that had this law been passed, he would have been in the court constantly as an adolescent. Madam Speaker, I thank you. Those are my thoughts on this bill.
So, Member Daly, are you still desirous of speaking? You may go next, after which it is Member...
Thank you very much.
Member from Manchester Northwestern, and then it will be the member from St. Anne Northeastern, after which it is the member from St. Catherine West Central. Did I see any other hands? And then the member from St. Andrew Southwest.
Thank you very much, Madam Speaker. Minister, I am so happy that you have deleted in Clause 6 and 7, in subsection 5, to replace it with 5A, as not having a violent behavior to... Are you... Minister? You're... Yes. I'm happy to see that you have moved violent behavior to just behavioral problems. But I have some concerns with other aspects of this amendment, and I want to speak straight to the social part of this amendment, the right of the child. I don't think in all of this we are taking in consideration the right of the child. Minister, we have a situation where children is not gone to school not because they don't want to go, but the conditions under which they live. Behavioral problems in the home, not because they want to behave bad, but because the environment creates that. I would want to see, Minister, some amendment that will really seriously protect the rights of our children. They have the right to good health care. They have a right to good housing. So all of these things we have to take in consideration when we are thinking about their behavior and what should be done to correct that kind of behavior. And I want to give you an example. There's a very good friend of mine who was thrown into a facility because the child did not know her parents. She was raised with a aunt, and she felt that she was abused. She was reacting, and they put her into a home. Now this child has become an adult, doing very well in the United States. She has a home, about nearly 200 nurses, about 100 doctors under her healthcare system. And she's still stigmatized. She cannot find herself. Don't care what she has achieved. She feels that because she went into that home and what she experienced also into that home caused her up until now to can't be rehabilitated. So we have to be extremely careful. I think it should be the last resort. And I heard you in the amendment speaking to, one, the monitoring at home if they are not being put into facilities. I would like to know the mechanism, what you're going to use, and what time frame are you thinking about in terms of the investigation, that the investigation should be done. Because if I can tell you from where I sit and from the work that I do outside of politics, that we have referred a number of cases, and sometimes the child even change before they even come to look at what is happening. So in this amendment, I think we should have a place where we put a time frame, where if there is any kind of disagreement, an investigation should be done, that there's a time frame given, and it should be the shortest possible time frame. Thank you.
Minister.
Mr. Speaker, seek permission to speak from a seat other than my own.
Granted.
Mr. Speaker, the Child Care Protection Act provides a framework within which the issues of children's rights and best practices is considered. The amendments to the Child Care and Protection Act that are before us focus on the uncontrollable child, a child with behavioral issues, and how we deal with that child in respect of the Children's Court, and how orders are made by the court regarding such a child, among other issues. I'll make a few observations, Mr. Speaker. We agree with the repeal of Section 24, which has been replaced with other provisions having to deal with the parent and child relationship. And we also agree with the inclusion of therapeutic orders, where the Act speaks to only a parent or the guardian of a child has a legal ability to take that child who is in their custody to the court in a bid to seek its intervention under this section. The logical consequence of this, if that fit person is a state institution that has been so designated by an order of the court, ought not to be able to just approach the court for the purpose of securing an order under this section. In essence, Mr. Speaker, if the child is placed in the care of the state, in a place of safety, or in a children's home, if management forms the view that that they can't manage that child, they in turn shift the responsibility to the care of the child to another arm of the state. This runs in contravention to the intent of the section. I do hope that the repeal of Section 24 deals with this issue, Mr. Speaker, as it now stands in practice. Mr. Speaker, the amendments in section 14.2a, we do welcome them. And that is where it was proposed in the section, which where the court itself sees that an inquiry was optional. And I see the amendments that have been made, Mr. Speaker, through you to the Minister, that the word may should be deleted and shall included. I do believe that for the judge to get a better understanding, Mr. Speaker, hence why I support this amendment, understanding of the child to whom the order is to be made, and to ensure the best order is made for that child and in the best interest of the child. The object of this exercise would be to also detect whether there are any underlying factors, such as untreated post-traumatic stress disorder, and for suitable treatment to be pursued in relation to the child's need. You may have other family members that may be also affected. Section 76, which outlines method of dealing with child offenders, I'm in agreement with the leader of opposition in his observation, recommending that this section undergoes further amendment, especially with regard to section 76(1)(f), which provides that a child be sent to a juvenile correctional center, that this option ought to be a measure of last resort, as this is equivalent to a term of imprisonment. For boys, it is Rio Cobre Correctional Center, and for girls, the South Camp Juvenile Correctional Center. And, you know, Mr. Speaker, especially to deal with the Rio Cobre, you have other children there that are there for other matters and not behavioral, and then you bring them into this will affect the child himself. Mr. Speaker, it is my understanding that we only have one therapeutic facility, which is housed at Maxfield Park Children's Home. We need to urgently find some fiscal space to erect more of these facilities across the island, fully staffed. These centers should be used as a first stop when the orders have been handed down by the courts. So in essence, you're not sending them to these correctional centers, but at least you're giving them the opportunity to deal with the issues that they face. While we do agree that action needs to be taken in respect to our children, we have seen drastic decay taking place in our home life and our society. But the real issue should be how we deal with the root cause and how it is that we cauterize what causes the psychological and physical stress that our children face, that causes them to have behavioral challenges. No child was born bad or was born a criminal or uncontrollable. It is life's experiences that have made them such. If we want to fix our society, then we have to, on the other hand, deal with the root causes while dealing with legislation in support to what the leader of the opposition said in his presentation. What of the rehabilitation of these children? The United Nations Standard Minimum Rule for the Administration of Juveniles state that a juvenile system should be fair and humane, should emphasize the well-being of the child and the goal of rehabilitation, and should ensure that the reaction of the authorities is proportionate to the circumstances of the offender and the offense. A range of factors must be considered when one seeks to determine what inures a child's best interests. One of the factors is the child's physical and emotional needs, and his/her level of development be taken into account. We have the opportunity for these children to become model citizens. if we make the right intervention. The larger question is, do we have the adequate psychiatric and social workers in the system? Most likely not. If not, then this needs to be urgently corrected. Mr. Speaker, we have children in shared facilities, adult detention facilities, even though we know that efforts are being made to divide the children from the adults. Just imagine the psychological negative effect this can cause on both our girls and boys. It is well established that even within our adult population, within our correctional facilities, we do not provide enough psychiatric intervention. To save our children when we can, a holistic approach has to be taken, not just amendments to legislation, but to include other factors that I have mentioned. Let us do the right thing from the start. We know what is needed, and we have the responsibility as legislators to make it right. It takes a village to raise a child, and we are a part of that village, Mr. Speaker. I thank you.
Mr. Speaker, I'm requesting permission to speak from a seat not my own.
Granted.
Thank you, Mr. Speaker. Mr. Speaker, I wish to add to the debate that is currently happening in relation to the amendments to the Child Care and Protection Act with this brief contribution. And I would just urge all members present that the amendments that are being considered are the amendments that were circulated this afternoon. The reason why I bring this to your attention is because I have heard in the presentations before statements related to the proposed Clause 2, which speaks to the definition of behavioral challenges as a cause for concern, and also other measures in relation to how persons with uncontrollable children would access the court system. There has been substantial changes to the amendments before the House, and I do believe that these substantial amendments to the amendments have come about from collaboration with civil society and from speaking with the various stakeholders. I also know, Mr. Speaker, that UNICEF played a very large role in these current amendments that we are actually debating, and I can see the smile of the Leader of the Opposition. Yes. Now, the Child Care and Protection Act sets out the statutory regime for, among other things, dealing with children with behavioral challenges. And the law as currently exists does create a situation where parents and guardians can directly take their uncontrollable children before the court, and these non-offending children can be given a correctional order for up to 3 years. The amendments that we are debating today will remove this from the law. Correctional orders will no longer be made in relation to non-offending children. And in fact, if we are to look at Section 36 of the Principal Act, you will see what is retained is that where a child is found guilty of any offense, they may be sent to a juvenile correctional center. So, Mr. Speaker, that is retained in the legislation, as Leader of the Opposition would have spoken to already, the part of the statutory regime that deals with offending children who have been found guilty. Now, we are all aware of the child diversion process, And this process focuses on children who are in conflict with the law. And that process seeks to divert children from interaction with the criminal justice system. And in fact, when you have an opportunity, which you should, you can look at the Ministry of Justice's website, where it boldly states that one of the goals of child diversion is to increase the use of diversionary programs that rehabilitate children as a response to crime and wrongdoing. And if it is that a child diversion program has the option of directing a child in conflict with the law to therapeutic options, then I dare say that a child with behavioral challenges ought to have the same, if not more, options. The amendments for the House today does no violence to the rights of a child, but instead it protects these rights. Substantial amendments have been made to Section 13 and 14 of the Principal Act, and you will see this as being Clause 4 and Clause 5 of the amendments that we are currently considering. I just want to state that in addition to the substantial amendments to Section 13 and 14 of the Principal Act, it is very important that Section 24, which allowed for correctional orders, is being repealed. Long overdue. But I want to focus my contribution this afternoon on Section 13. This reformulated Section 13 of the Principal Act creates that triage that has been mentioned in this House today. Firstly, it removes the ability of parents and guardians to take their children with behavioral challenges directly before the judicial system. Instead, parents and guardians may now make an application to the government agency with responsibility for children for them to make a determination of the appropriate treatment and support. What is very interesting about this proposed amendment is that this application will trigger a mandatory assessment of a child by a behavioral specialist who can properly determine the appropriate treatment and support. For children not requiring a residential treatment plan, a care plan must be issued to the parent or guardian. And I must say that a roadmap is always very important for addressing issues where you need to reform behavior. And this is now provided for. It's a mandate under the proposal currently before the House. For the children who require residential treatment, it is then and only then, Mr. Speaker, that those children will be brought before the court. In fact, the only other time a child with behavioral challenges will interface with the court system if it is that the Child Protection Agency or any other agency who is mandated to deal with the rights of children has received report or it has come to its attention that the child is not receiving treatment as set out in a care plan. These, Mr. Speaker, are very important reforms relating to children. Today is a day that we can and must act in the furtherance of protecting our children. These amendments have been drafted, taking into account the real-world situations confronting the courts, the government agency with responsibility for children, the police, parents, and guardians. And at the same time, it is respectful to Jamaica's treaty obligation as it relates to the rights of the child and the concerns of civil society. I give my full support to these amendments, and I would urge the other members of this Honourable House to do so as well. May it so please you.
Thank you very much, Mr. Thank you. Thank you very much, Mr. Speaker. Mr. Speaker, colleagues, I rise to give a public health perspective on the Act to further amend the Child Care and Protection Act and to provide for connected matters. Mr. Speaker, the Ministry of Health and Wellness notes the statement made by the Minister of Education and Youth, the Honourable Fayval Williams, on June 26, 2023 in this Honourable House on the treatment and rehabilitation of children referred to facilities operated by the Child Protection and Family Services Agency by order of the court under Section 24 of the Child Care and Protection Act. Mr. Speaker, we note the position of the said ministry that allowing the use of a correctional order without a child committing a criminal action under Section 21 of the Child Care and Protection Act is an injustice against the child who may be exhibiting trauma derived from abuse, neglect, and suffering and needs psychological treatment. We also note the actions of the Ministry of Education and Youth to amend the Child Care and Protection Act, which will include the repeal of Section 24(2) that will enable Jamaica to become compliant with its obligations under notable international treaties, Mr. Speaker, on child justice, child rights, and establish a fairer and more equitable means of treating with cases involving child exhibiting behavioral challenges, thereby promoting the best interests of the child. The amendments, as we understand it, will include repealing Section 24 of the CCPA, which makes provisions which may include a correctional order regarding the treatment of a child brought before a court by a parent or guardian who claims to be unable to control the child. But importantly, the involvement of the CPFSA, which I know the leader of the opposition missed, and I understand why you were not privy or certainly did not look at the amendments, the further amendments that were distributed. But I think it's important to place on record, and I'm sure the minister will deal with it, that your suggestion was already incorporated, and therefore we're even more aligned, which is good. So I recognize that, and for emphasis, and do appreciate the comments that you raised, as I am sure the minister did, which is what led to the amendments. The making of provision for the orders that may be made by the court in respect of such a child to include a residential therapeutic order or a non-residential therapeutic order having regards to the result of social inquiry report, psychological or psychiatric report in respect of the child order by the court. And finally, D, provide that a children's court, before which any child is brought under Part 1 of the Act, other than a child alleged to have committed an offense, may order that the child be placed under the care of a children's officer for a specified period not exceeding 3 years, instead of the probation and aftercare officer as currently obtained under the Act. So those are things, Mr. Speaker, that we support and we think acts in the best interest of the child, and frankly speaking, is long overdue. The Ministry of Health and Wellness is of the strong view that these legislative actions will provide a more significant rehabilitative benefit to the population of children who are in need of services, psychiatric and otherwise. The proposals for amendment, Mr. Speaker, is in the interest of public health, as we see in many instances where challenges faced by families are a function of mental health issues, and the result, of course, is behavioral outcomes. Many studies have shown that early intervention in the formative years are very effective in not only alleviating the issues affecting the family, but also the success of intervention ensuring recovery. And, Mr. Speaker, I would like to elaborate on this, because the truth is, this administration, Ministry of Health and Wellness, government of Andrew Holness, has done more, I believe, than most before us in terms of mental health intervention. And we have done so at all levels, in particular at the level of our young people, our children. And I can give you a number of tangible cases. You would have or may not have seen our intervention in terms of safe space creation at the school level, the unveiling of our wellness benches, which is symbolic, although tangible, the training of school administrators, over 500 plus have been trained in psychosocial support intervention to recognize our young people when they are going off the rails, look at the signs of, withdrawal, deviant behavior, etc., and then intervening. We have a community-based intervention called Problem Plus in collaboration with the Pan American Health Organization, which addresses issues around community leaders intervening within the community, which will address also issues related to families and children. And up to last week, I was in the West meeting with parents around their own safe spaces and also an approach to addressing any concerns that they have. So the contribution from the member just before my colleague on this side, Member Phillips, calling for additional interventions without resorting to the court. I want to just address that by saying there are many such interventions that are taking place right now. I'm not saying it's enough, but a lot is happening, and indeed I believe more than before. There is an issue with capacity. We don't have a lot of psychiatrists and psychologists. They are just not available, which is why we have collaborated with agencies like PAHO to provide the psychosocial training for intervention, and which is why the Problem Plus program exists. So I want to say that we are taking a holistic approach, member, and this adjustment in the legislation will, I believe, bolster that, because the truth is there has to be different approaches to the extent that the problem exists. It's not one size fits all. Jamaica is facing, Mr. Speaker, a significant challenge with things like substance abuse. Many young Jamaicans who currently abuse substances such as marijuana, cocaine, or even more recently and increasingly popular, the drug Molly, are affected in terms of their behavior, in terms of mental health related issues. And the reality is that if the law is broken, the penal institution is the worst place to send that child, that age cohort. That's not rehabilitation. That actually makes the child worse. So this is why this is so important. I quote from a 2019 paper published by the Office of Juvenile Justice and Delinquency Prevention in another jurisdiction in the United States that shows that for severe behavioral and emotional troubled youth who have been referred to residential treatment centers and who are provided with individual treatment plans and provided with intensive multidisciplinary treatment have a significantly better recovery outcome than those who receive no treatment or have been placed in secure detention facilities. So even with the best practices, leader of the opposition of the international agency that you cited, the reality is that there are studies, practical studies, that shows that the intervention that is now a part of this legislation has worked in other jurisdictions. These services are provided to young persons who are most at risk for self-harm, have violent tendencies that make it difficult for outpatient care. These centers follow, as we understand it, and of course the Ministry of Health is prepared to be a part of this and is a part of this, a rehabilitative and trauma-informed model that examines the case history of each child in order to provide the best treatment within a much more conducive environment. In a 2009 study titled Adolescents in Residential and Inpatient Treatment, a review of the outcome literature, it was found, Mr. Speaker, that residential treatment centers offer a viable option for the state as it seeks to provide good outcomes for juveniles who are in need of specialized care. Mr. Speaker, the use of residential treatment centers and the development of appropriate treatment programs targeted at these at-risk youths is a critical next step in dealing with the many mental health and substance abuse issues that are affecting our youth at this time. In closing, the amendment of the law to allow for the CPFSA and the courts to be able to provide these therapeutic interventions in a society where we have broken families more than we don't. That's a reality. And that's another thing that I think it's important to recognize, the context of the circumstances that we're dealing with. Because oftentimes we apply what we classify as best practices because they may be international in nature, but very often ignores the challenges on the ground within our society. And I don't think it is appropriate so to do. So, member of the leader of the opposition, it is not always advisable, although a good guide, to suggest that we are off course because we are not adopting in a wholesale way the best practices that have been exposed by the multilaterals, although they are very important partners, and we accept that. So, Mr. Speaker, the Ministry of Health and Wellness and the team is fully supportive of the amendments being proposed by the Minister and the Ministry of Education and Youth. We applaud them. We think they are transformational. We think they will go a long way in terms of the public health response which is needed, and it certainly complements and supports and bolsters the efforts that we are making in collaboration with the Ministry of Education around mental health response that is prevalent in our society today. I thank you, Mr. President. Mr. Speaker.
Thank you very much, Mr. Speaker. Mr. Speaker, unlike the two speakers who went before me, I am unable to speak to the amendments that I saw not so long ago. And I want to start by saying that we need to have a more collaborative approach to ensure that the debates in the bill from all of us are measured, are appropriate, and take into account the actual amendments and documents before us. So, for example, a couple of weeks ago, on this side, we insisted and asked for a delay in the discussion, and the minister acceded. Right? No, eventually. No. Yeah, it was eventually. No, it was eventually because she even started by saying why she wasn't doing it. But that's fine. That's fine. We got there. One would have expected, therefore, if there are other amendments. Mr. Speaker, one would have thought that if amendments are being made that would change what we had received in Parliament as the set of amendments, that courtesy, common courtesy, would have been afforded to members on this side, so that as we prepare for our intervention today, we could actually speak to the amendments, some of which we had started to enunciate from then. So today, I came prepared to speak on the amendments before me, and that's exactly what I am going to do, because I can do nothing else. I believe all of us, and we have said that before, actually are in agreement with the repeal of Section 24 of the Act, which makes provision, which may include correctional order and all of that. And we are grateful for the change that we see. I will not talk about this long list of behavioral changes, except to say that when I read some of them, I believe that I would, growing up as a child, have been taken to these treatment centers on several occasions. Yes, just by virtue of some of the things that are here. Staying out late. Yes, for example. Yeah. Engaging in disruptive activities at school. When you are at school and you talk to the student beside you, the teacher says you're disruptive.
When teacher boring.
No, that's what teacher says. Yeah. When you're talking to somebody beside you. So if a disruptive behavior in school can be that, then it means that this would then be applicable. So I am pleased to see or to hear that some of the concerns we had about that broad list, we understand some of the more severe cases that would be taken before a court. But our main thing was that there was some other behavior that could have been addressed without actually getting to court. I heard the Minister of Health talking about some of the intervention in school around mental health and so on. The original amendments that I looked at did not reference those as part of the suite of options to deal with our children and their behavior, which was the concern that I had. In fact, something staying out late, no, there's one about staying out late and, okay, staying out late without reasonable explanation, such that the child would reasonably be considered as exposing himself or herself to danger. And that sounds logical that it should be there. But hey, it depends on where you live. Because where you live, possibly spending 10 more minutes at school is putting you in danger in terms of getting home. Because we live, some of us, in some violent communities. And so who determines what is late and what is exposing to danger? All of these are issues that, to me, require some kind of a understanding and almost a definition in terms of that. The minister spoke about the approach to mental health, and I agree with him. These days, one is that we are recognizing that mental health and dealing with mental health is normal. It's not an aberration, and it's not something to hide. That wasn't so before. Since COVID, we have also seen that there are greater challenges to many of our students, adults in fact, in terms of their mental health issues. And so there is more to be dealt with. And again, I'm glad to hear the Minister of Health then talk about what they're doing in school. As I said, oh no, yes, I'm commending that you have said that. I have no difficulty doing that. Absolutely none. No, absolutely none. But I want to point out that those were not options included in the amendment that I read when I prepared to speak today. And so it must be clear, because quite frankly, what it means is that if we had not insisted on the delay, these amendments that we are talking about today would not have been included. Because no, they were not in the amendments that were tabled. They weren't. No, man, no, I have to talk truth. I have to talk truth. No, I have to talk truth. You can't have your cake and eat it. No, so I just want to make sure that we are clear about that. The idea of making sure that only severe cases really reach to the court and that there are other alternatives. So, for example, when you talk about bringing them before the court and saying, for example, that having regard to the results of any report or assessment made under subsection 2A in respect of the child, that the orders that you could make, the decisions you could make, is for a non-residential therapeutic order if results indicate that the child has behavioral challenges. The question is, why do you have to come to court to hear that? Why isn't there a mechanism to be able to do that? I have to talk what I come prepared to talk. No, I know it wasn't included last time. No, it wasn't. And again, I come back. You know, I said when the minister did not even make an attempt in the last bill to respond to the questions on this side, that is a sign of contempt in terms of how we treat the opposition and our right to engage in the debate and conversation. And I see the withholding of the document with all the amendments before today's discussion also as contemptuous. I say that again because I believe we need to give every member the opportunity to come prepared for a proper debate. And when you bring, yes, an issue, a new set of amendments that were never contemplated, some of which we had wanted and had started to talk about. such that members of the government come prepared to speak about those amendments, which means that you would have had it. I expect that. That's fine. But those of us on the opposition benches come without that preparation, and then some persons would want us not to speak about it. It's a big deal. It is a big deal. Yes, because it is a big deal. 5 times a big deal. No, right, no. So I really want to say that. You know, there is a well-known African proverb that says that the child who is not embraced by the village will burn it down to feel its warmth. Yeah? And this is kind of really what we're talking about. And this is what repealing Section 24 and the provisions that we are laying out are meant to do, to make sure that the child feel the warmth, feel the care, such that they are not tempted to burn it down to feel any kind of warmth. I wanted just to say as well that even from what the Minister of Health read, what is clear is that the more severe cases are the one that you would send to these centers, and the others you would try to deal with in community, by the family, as we are doing with adults just now. And in fact, our history of what many of us would know as family, yeah, is that it is a hellish place to be. Family is a hellish place to be. And therefore, anything that harkens to a center of that nature is something to be avoided and to be deleted. I am going to take some time while the debate continues to read the new amendments that have been tabled today so that I can get up to speed with where we are. 6 is my limit. Thank you very much.
Minister.
After you apologize. Sure. Madam Speaker. Madam Speaker, I'd like to thank my colleagues for their contribution, and to note, Madam Speaker, that following the suspension of the debate, we received comments from stakeholders on the bill, and those comments were considered by the Ministry of Education and Youth and the Child Protection and Family Services Agency. In light of the comments received, further drafting instructions were issued to the Chief Parliamentary Counsel, and as such, I have a list of amendments to be moved today in this Honourable House. Madam Speaker, the amendments have been made to remove the definition of behavioural challenges under Clause 2 of the bill. Madam Speaker, the amendments have also been made to allow for a parent or guardian who believes that a child is exhibiting behavioral challenges to first access support through the CPFSA rather than bringing the child before the court. The CPFSA will have the child assessed by a competent behavioral specialist to determine whether the child is in fact exhibiting behavioral challenges and determine the support needed. Madam Speaker, where it is of the view that the child needs to access treatment in a residential environment, the matter will be placed before the court with a social inquiry report, a copy of the report of the behavioral specialist on the assessment, a care plan, and the recommended duration of treatment, which should be a period not exceeding 1 year. Madam Speaker, on the other hand, where a child is being treated in a non-residential setting, it has come to the CPFSA, and it has come to the CPFSA that the child is not receiving treatment in accordance with the care plan, the child will be brought before the court by the CPFSA for an order to be made as the court considers fit to resolve the matter in the best interest of the child. Madam Speaker, it is hoped that with these amendments, we will see a decline in the number of children to be treated in a residential environment, and treatment will begin immediately for those children when they are referred to the CPFSA. In this regard, the Child and Family Support Unit of the CPFSA will be strengthened to have the competent assessors to treat with these matters. And I think that was a question that the member from St. Catherine was asking about just what happens practically on the ground now. So with these amendments, we obviously have to move to increase the resources to the CPFSA so that parents who come in to the CPFSA, they don't have to wait an inordinate amount of time to get their assessment. Yeah. Madam Speaker, the amendments will also seek to indicate the duties that the children's officer will undertake where a child is placed under the supervision of the children's officer pursuant to the amendment to be made to Section 14(2) of the Child Care and Protection Act. Madam Speaker, the amendment is also seeking to substitute the words violent behavior with the words behavior that may cause harm to the child or to another person in the new subsection 5A under the bill. Madam Speaker, with these comments, I close the debate on the bill and now ask that the bill be read a second time. Thank you, Madam Speaker.
House Leader, we're going to read the bill a second time. I would just like to point out something in the standing order because I realize it was almost done in jest. I want to just remind persons of a particular section of the standing order. So, Clerk, please do the second reading, and then I will just point out section of the standing order. Those in favor of the reading of the second bill? Those against? The ayes have it.
A bill entitled An Act to Further Amend the Child Care and Protection Act, read a second time.
Thank you, Clerk. Members, I notice in jest the statement was made that a member was repeating themselves for 5 times and could do so a 6th time. Standing Order 43, order in the House and in committee, requires that where members choose to either repeat themselves over and over, as has happened in this House, or get up to say, I am agreeing with and repeating in a debate what was said by another member, the Speaker or Chairman, if it is a committee, is at liberty to direct that member to discontinue his speech and to resume his or her seat. So, as a general caution and reminder, we are actually not at liberty to repeat, nor are we allowed to repeat what others have said. We are supposed to be efficient and succinct at dealing with the people's business. Too charitable. I'm usually very charitable myself. Very much. Marshal, the House will now resolve itself into a committee of the whole House to consider the bill clause by clause. We will now take the bill clause by clause. I put clause 1. Is there any amendment to clause 1, Minister?
Yes, Madam Speaker. But could I say before we get to clause 1, in the long title, Madam Speaker, I ask that we delete the word further. You want to look at this?
Minister, we will put clauses first and then the title and enacting clause. So we will start with clause 1, if that's okay.
Sure, thank you. So in clause 1, Madam Speaker, we have an amendment to delete from subsection 1 the words in parentheses number 2.
Those in favor?
Aye.
Those in favor?
Aye.
Those against? The ayes have it. I put clause 2.
Madam
There
Speaker,
is an amendment.
The amendment is to delete the clause 2.
Those in favor?
Madam Chairman, just before you go, just to point out, this is a very significant amendment because Section 2 or Clause 2 of the bill is the clause which had included this new definition of behavioral challenges, which had that long list of a spectrum of behaviors, some of which really are normal aspects of acting out by adolescents and some of which may be more serious in nature. So the removal of that is an important improvement to the bill, and I'm just glad that the minister took the time, under some amount of pressure, not to complete the bill 2 or 3 weeks ago, which has facilitated these amendments, which are very substantive, being introduced. Otherwise, the bill would have been passed in its original form, which would have been a bad thing. So thank you, ma'am.
Opposition Leader, thank you very much for reiterating the statement made by yourself before and Member Brown-Burke before.
I didn't say it before, but I said it now.
Minister, did you complete the comment that you would like to delete clause 2?
Yes, Madam Speaker. Delete the clause 2.
Those in favor?
Aye.
Those against? Those against? The ayes have it. I put clause 2 as amended. Those in favor?
Aye.
Those against? No, I know, but I am making sure if it is deleted that you are taking into consideration the amendment. The amendment was to delete the clause. I put clause 2 as amended. Those in favor?
Aye.
Those against? The ayes have it. It's deliberate. Member Golin. Clause 3. No, so, having put the clause, I am actually required to ensure that that amendment for the clause is also voted on by the House. So it is an unusual one where the entire clause is being deleted, but we are, out of an abundance of caution, ensuring that persons vote as well as it relates to the amendment.
Yes, so you put the deletion of the clause.
Yes, that's it. That's what we're doing. And as a matter of fact, let me put clause 1 as amended. Those in favor?
Aye.
Those against? The ayes have it. I put clause 3.
Madam Speaker, I ask that we renumber the clause as clause 2.
I put to the Parliament those in favor of the clause being renumbered, clause 2. Those in favor?
Aye.
Those against? The ayes have it. I put clause 3 as amended to clause 2. Those in favor?
Aye.
Those against? The ayes have it. I put clause 4.
Madam Speaker, I ask that the amendment to renumber the clause as clause 3.1. And in clause 3.1, as renumbered, in paragraph C, delete the words "a parent or guardian of the child"
Minister,
and
there are a
substitute.
series of amendments to clause 4, and they're in the amendment sheet. So you could just say that you're proposing the amendments as set out in the sheet, because it's over a page of amendments to this particular clause. So you don't have to read them all.
Minister, before you continue, I think I saw Member Brownberg's hand up.
Right. I just wanted a clarification, Minister. I know that we are about to delete a parent or guardian of the child and all the rest of it. So, yes, the parent of the child can refer to an agency dealing with children matters. That's one. But in many communities, parents have a good relationship with the police station that's in the community. If they go to the police station for intervention, does that then what are the options open to the police? I'll be honest, I'm trying to read it, but I can't read both of them like that. So I require a little guidance here. So if the parent, as so many do, go to the police station with Johnny because they want the police to talk to Johnny for something that Johnny is doing, what are the options available?
For example, Minister, on that same point, in the new subsection 3, which is part of the amendment to clause 4, now renumbered clause 3, where it makes reference to the parent or guardian having the capacity, may make an application to the government agency responsible for children. Could the police, at the request of the parent or guardian, or with their consent, make that application to the government agency responsible for children if the child was, or if the parents invoked the assistance of the police as the sort of authority within the community that they're aware of? So it doesn't make any reference to the role of the police, but, you know, as has been said, in several communities, they do play a role de facto. So would they be authorized to make that application with the consent of the parents? The application to the government agency. If that was considered to be beneficial, it's a very simple amendment to the new 13.3 to do that. One could just insert, the drafter could insert language to do that.
But I ask you, member, if you approach the police, aren't you engaging the security apparatus of the country? And isn't that what we're trying to get away from, where we want to encourage parents, we want to raise the awareness about the Child Protection and Family Services Agency so that parents think first to go to that agency to get the assessment done by the behavioral specialist, by the psychologist or psychiatrist, to have the report done and an assessment made about the range of behavior. Where does the behavior fall on the spectrum of behavior? Do we have normal behavior that can be dealt with 2 or 3 sessions in a therapy session? Or
Minister,
do we have something worse?
I was impressed with the intervention of the Minister of Health and his plea for us not to just apply standards that are elsewhere, but to take into consideration our cultural norms. And that is what I'm trying to do. Which is that in many of our communities, the person you call when you have a problem with your child is the police. It is, I can't understand why we would not allow them the option of actually bringing in the government agency, as they do for many other things. Absolutely.
No, but Chair,
Police don't just operate.
Chair, I don't want. I hear the members, but I'll say a couple of things. I am very wary of inserting the police directly in this process, because I believe we may be going back to a situation that we're trying to get out of. The situation that we're trying to get out of is to try to avoid our children interacting with the criminal justice system when the matter is not criminal, right? In other words, there are behavioral challenges. I do understand the point that oftentimes parents may call upon the police, but having called upon the police, what the section does is give the parent or guardian the authority, the right to make the application to the child agency. I do not believe we need to insert who calls the agency. Who literally calls the Child Protection and Family Services Agency is not of any moment. But who has the authority is what is of moment. And I think the authority is rightly placed with the parent or guardian of the child. I don't believe we need to insert the police to give them the authority, because what it would suggest, I would say, members, is that it would suggest that they may be able to do it in absence of the parent and guardian. If they can't do it in absence of the parent and guardian, then leave it as is.
You wanted to say something? No. My point is a very simple point, that often, even with our police, if someone brings a child to them, what are their options? That is the reason why I asked it as broadly as that. What are their options? If you say to me that their options will include recommending that the parent calls an agency, I am fine with that. Let me tell you what the difference is. The difference is that if we do not contemplate it in the drafting, chances are in the orientation to our police officers, that's not there. And so if a parent brings a child to them, as far as they're concerned, they have one option, which is to carry them to court. And that is the simple thing that I'm asking for.
So, member, in the original amendments, the amendment of Section 13 of the Principal Act, the police is there already. It says any of the following persons may bring before a children's court any child in need of care and protection, and that includes a constable and authorized person. But in the case of a child brought before the court on the ground that the child is a child with behavioral challenges, any person referred to in this paragraph A or B, that part is where we're amending to have the government agency responsible for children be the one to do the assessments, and based on the reports, then to bring the child in front of the court. It's already there.
No, when framed like that, it's in keeping with what I'm asking for. What I'm saying is, in the original, it says any of these persons could bring the child before the court, including the constable and authorized person and so on. This one doesn't make any reference to that. The point I'm making is that the reality on the ground is that a parent is going to carry the child to the police station to say, talk to him, talk to her for me because of A, B, C, and D. And I just want to make sure that in the law that we're passing, that the police know that an option that is available is the intervention of the government agency, because it's not clear in how it is set out.
So again, just
so member, we'd have, go ahead.
But I was just going to indicate, definitely, not just from anecdotal, but from my time at the ministry, that obtains. That is the status now. In other words, the police know that when a child is brought to them, especially for a non-criminal matter, that they're referred to the Child Protection Agency. So I don't think this offends that or we need to go any further.
What's the harm in not including?
No, it's already, I would say it's already covered. Yeah.
In?
What Minister had indicated is that the Principal Act already indicates that
No, but she's amending section 13 now.
Understood.
It's new amendment here. So she has taken out the word constable out of it?
No.
So this is it.
The amendment, member, is at paragraph C. Yeah. It's a paragraph C, where we're substituting at B, instead of it saying, or a parent or guardian of the child, we're substituting the government agency responsible for children.
I think I've made my point. I mean, the intransigence that we normally see is again being invoked. And I mean, it doesn't make any sense for me to continue with the conversation. So I yield.
Minister, if you are finished with the clause, I would like to put clause 4, which has been replaced with 3 amendments and now noted as clause 3 to the Parliament. Those in favor?
Aye.
Those against? The ayes have it. No, well, 3, I'm doing all of 3. So 3.1 having the amendments, so it has 3 amendments in that section. So I'm putting the 3 amendments within it. Instead of having a discussion piece by piece, is to take the entire amendment section and putting it to the House. So we now put the clause as amended. Those in favor?
Aye.
Those against? The ayes have it. I put clause 5.
Madam Speaker, the amendment there is to renumber the clause as clause 4. And in subsection 1B, in the new section 14.2H, insert next after the words subsection 2A.
Minister,
yes?
It is not necessary to read out the amendments. Persons, unless they so desire otherwise, could just look at the gross amendment sheet and we take the amendment as per the summary of amendments. So we would put the 7 amendments in that clause to the Parliament. So persons, please be guided, follow the amendment sheet. It is easier for them to appreciate. So I now put clause 5. No, I don't want to put 5, 6, and 7. Which is amended to 4. I don't want to put 6 and 7 yet. I don't want any confusion. With 7 amendments. Those in favor?
Aye.
Those against? The ayes have it. I now put the clause as amended. Those in favor?
Aye.
Those against? The ayes have it. Clause 6 and 7.
Madam Speaker, the amendment is to renumber the clauses as clauses 5 and 6.
I now put clauses 6 and 7 to the House for amendment. Those in favor? Aye. They will now read clauses 5 and 6. I now put the amended clauses to the House. Clauses 5 and 6, previously which read 6 and 7 as amended. Those in favor?
Aye.
Those against? The ayes have it. I now put clause 8.
Madam Speaker, as amended, I put clause 8 as stated on the amendment sheet.
All right, so we are taking out...
Delete the clause and substitute, therefore, the following.
And substituting
renumbered as clause 7.
Renumbered, amended clause at 7. So I put clause 8, amended and renumbered with notations therein for clause 7 to the House. Those in favor?
Aye.
Those against? The ayes have it. I put the amended clause 7 to the House. Those in favor?
Aye.
Those against? The ayes have it. I see no amendments to schedule, so I will put the title and enacting clause. Mr. Green first. Minister, hold on a moment.
Before you put the title and the enacting clause, Chair, I just wanted to use the opportunity now that we're in committee and we're finalizing the bill to commend the Minister of Education and Youth for getting us to this point, Minister. Chair, for years,
Minister, sorry, if I could just ask one question, if I may. I realize I'm intruding on the accolades, and I apologize for that. But there was just one question I had. In one of the amendments, which was the amendment to Clause 5, and there's a new subsection 2A in brackets being inserted, and there was a deletion of the word may, and substitute therefore the word shall. But in the bill, there are two references to may in that section 2A. There's one in the chapeau, the opening words, and there's one in paragraph 2A, the little a paragraph of 2A. I was wondering which of them this was intending to refer to, or is it both?
So, hold on.
Didn't mean to.
Committee members, please bear with us and give the Minister a little time.
Thank you, Madam Speaker. I just conferred with our technical persons, and they're saying that that should be 2AA.
But isn't it a standard practice at the CPFSA that once a child comes into their interaction that they do a social inquiry? Right. So even with this, as a part of their processes, a social inquiry is a part of their, once a child comes into their interaction.
Yes, member. Right, so Madam Speaker, I said I conferred with our technical persons, and that should read, well, 2AA.
Minister, that would not be treated as an additional amendment. However, noted for update. Yeah, not an additional amendment. So, Minister, it will be treated as a correction and not an amendment. All right? So, are you ready now, Minister?
Before the intervention, Madam Speaker, I was saying on behalf of the committee how grateful we are to the Minister of Education and Youth for the hard work that she has done to bring it to this point, along with her technical team, the Child Care Protection and Family Services. Madam Speaker, many governments promised to make this change and never made it. I'm very proud that this government is getting it done.
Madam Speaker, I too would like to add my voice, particularly as it relates to the provision of therapeutic services. I remember many years ago, a former Minister of Youth planned to have a therapeutic center, but it ended that we're searching for the land. And you as minister was able to not only find the land, but get JSIF to build the therapeutic center, an outpatient first class, first in the Caribbean. We're very happy about that. We're also very happy as well of another therapeutic center somewhere in St. Anne, which is a fully retrofitted facility that not only will help the young children, but also protect them from outside influences. And I think it's a very transformational and revolutionary actions are taking place in relation to children. And I think the Ministry of Education, the CPFSA, the team that is here to support, should be commended for the great work that has taken place over these last few years. Thank you very much, Madam Speaker.
Minister. I'd put clause 8 as amended. So, Minister, I'd put clause 8 as amended, and it was voted on, and the amendments accepted, and the correction does not relate to clause 8. So I'm moving on to putting the title and enacting clause.
Madam Speaker, for the long title, the amendment is to delete the word further.
Those in favor? Those against? The ayes have it. I put the amended title and enacting clause. Those in favor?
Aye.
Those against? The ayes have it. The question is that I do report the bill as having passed committee stage with 17 amendments. Those in favor? Aye. Those against? The ayes have it. I do now report the bill as having passed committee stage, now in the House with 17 amendments. Thank you, members. Minister, please ask that the bill be read a third time.
Madam Speaker, I now ask that the bill be read a third time.
The question is that the bill be read a third time. Those in favor? Aye. Those against? The ayes have it.
A bill entitled An Act to Amend the Child Care and Protection Act, read a third time and passed.
We're still at public business.
Madam Speaker, there are two matters on public business to complete that element of the agenda, and then I'll ask for a recommittal of motions that require, sorry, just to make sure we have it right. Presentation of bills without leave of the House first obtained, so as to allow the Minister of Finance to have the first reading of the bill that he tabled earlier on. So, Madam Speaker, the Minister of Legal Affairs and Constitutional Reform will now take the bill in her name.
Madam Speaker, I rise on the bill entitled An Act to Repeal and Replace the Bail Act and to provide for connected matters, of which notice of second reading was given by me last Wednesday, July 19, 2023. Madam Speaker, the matter of bail in criminal proceedings has been hotly debated in the courts of law as well as in the court of public opinion. The truth is that the matter need not be treated as contentiously as it has been treated in recent times, once we clearly understand and have a better appreciation of some fundamental principles. Madam Speaker, the right to bail rests on the fundamental principles that every person is entitled to his liberty. The right to liberty, however, is not absolutely guaranteed under the Constitution of Jamaica. It also rests on the other principle that every person is presumed to be innocent until he has been proved or has pleaded guilty when charged with a criminal offense. And this, Madam Speaker, does not mean that the person suspected or formally accused of an offense did not commit the offense. It means that the person cannot be convicted before going through a formal process. Until the enactment of the Bail Act 2000, bail was determined in Jamaica in accordance with common law principles. Madam Speaker, the 2000 Act was enacted against a background of burgeoning murder rate, a proliferation of illegally held firearms, and an increasing level of gun violence. Not long after the enactment, the then Chief Justice made calls for even tougher rules for bail in serious crimes in response to higher crime rate, intimidation of witnesses, and the commission of offenses by persons who had been released on bail. As a result, Madam Speaker, attempts were made to amend the Bail Act 2000 by a series of anti-crime bills in 2010. those matters were met with mixed faith, and we have taken note of the constitutional issues that arose and were pronounced on by the courts in the Nation and Right against the DPP and the Attorney General case. Madam Speaker, it has been a little over 2 decades since the Bail Act was enacted. The state of the law has been reviewed and changes are being proposed to keep the law apace with peculiarities in the Jamaican society, including the scale and characteristic of criminal conduct and challenges regularly encountered by the police to convert intelligence to evidence, to ground charges, and to hold those who commit heinous crimes to account without having persons who should not be in custody longer than is required. Bearing in mind that time does not generally run against the state in the prosecution of offences, the interest of justice is best served when those who commit heinous crimes, in fact, those who commit all crimes, are held to account, and especially when they brazenly intimidate or threaten witnesses. In addition to the situation around crime, Madam Speaker, the Constitution of Jamaica was amended in 2010 with a new Charter of Fundamental Rights and Freedom replacing Chapter 3. The Child Care and Protection Act was also enacted, and we just completed amendments to important provisions of that act. The Children's Court was established, and the Juvenile Act was repealed. The Charter of Fundamental Rights and Freedom recites the obligation of the state to promote universal respect for and observance of human rights and freedoms, the entitlement of all persons to preserve for themselves and future generations the fundamental rights and freedoms to which they are entitled by virtue of their inherent dignity as persons and as citizens of a free and democratic society. The responsibility of all persons to respect and uphold the rights and freedoms recognized in the Charter. Madam Speaker, I don't think it can be repeated too often that the recognized rights and freedoms are protected to the extent that they do not prejudice the rights and freedoms of others. Parliament is at liberty to intervene where appropriate and when necessary to restrain and regulate competing interests of liberty and freedom. Madam Speaker, it is unfortunate that we do not sufficiently emphasize the duty of individuals. The simple truth is that democracy is not just a regime of rights. Democracy is also a regime of duties. This is obvious regarding relations between individuals. The right of A is a duty owed by B. But it is also true regarding the relations between the individual and the state. These relations are made up not only of the rights granted to the individual towards the state, they are also made up of the individual's duties towards the state. Beside the right of an individual stands his duty towards a fellow individual and his duty towards the state. Because, Madam Speaker, it is well recognized and documented that unrestrained liberty can be the antithesis of the liberty of others. Democracy, Madam Speaker, is based on living together and on national interest. The government acts for the good of the public. For that purpose, it must be granted rights in the wider sense of the term. Otherwise, it will not be able to fulfill the interest of society. Granting rights to the government means imposing duties towards the government upon the individual. These duties are intended to enable the government to achieve the goals expected of it in a democracy. They are derived from the circumstances of living together and from the need to advance the liberty of each and every individual. They are derived from the society's demands of the individual as part of society to act for the good of society. They are the result of a balance between the needs of society and the rights of the individual. Madam Speaker, in addition to what the Charter provides for, it must also be noted that the concerns which gave rise to the enactment of the Bail Act and attempts to amend it in 2010 have not changed, particularly in relation to the levels of violent crimes, which have increased significantly over the years. This bill, entitled the Bail Act 2023, therefore represents an overhaul of the law on bail after a thorough review, and it reflects consideration of internationally accepted best practices as well as taking into account local realities which we cannot escape. After extensive and at times intensive deliberations by the Joint Select Committee appointed to consider the bill, I now present to this Honourable House the bill that represents the outcome of our deliberations. Madam Speaker, it should be reminded that the Committee of the Joint Select Report, which was approved by the House last week, had a recommendation for the withdrawal of the initial bill and a retabling of a bill that reflected the deliberations of the committee. Madam Speaker, this bill seeks to address the grant of bail in a holistic way, encompassing and clarifying the grant of bail at 3 stages: before charge, after charge, and after conviction. And the bill cogently sets out the scheme for bail to avoid doubt and unintended consequences. I will now outline the provisions of the bill clause by clause, and I should like to, at this point, thank the opposition for their cooperation. The deliberations on the initial version had interesting moments, testy moments at times, but we were able to go through the issues respectfully, and all came away from the deliberations indicating that much was learned. Madam Speaker, since last week, I also asked whether there were any remaining concerns from the opposition, and the Leader of Opposition was kind enough to send some issues. These issues are by no means contentious, and I do believe that they can be easily addressed. In fact, I have since exchanged responses with him, even though we are still discussing one of the provisions, which we will discuss as we go through in committee stage. So, Madam Speaker, Clause 1 recites the short title of the Act, which is the Bail Act 2023. Clause 2, standardly, is the interpretation clause. It sets out the defined terms used throughout the bill, for which some of the terms of the 2000 Act have been retained, and also new terms have been added. Among the new terms, arrested is included is defined to include apprehended, and this is to ensure consistency with the Constabulary Force Act. Child is now defined as a person under the age of 18 years, and this change brings the definition of child in line with the Child Care and Protection Act. We have an umbrella term of deciding official, and it refers to the persons empowered in the Act to make decisions concerning the grant of bail. And these are the police, at or above the rank of superintendent, a justice of the peace, and a judge, reflective of the scheme of the law where bail can be granted out of court as well as by the court. The term constable is used because it has a particular meaning in the Interpretation Act. It does not mean the actual rank of constable, but it means a member of the constabulary force. For the purposes of this Act, the constable in question, who is the deciding official, is at or above the rank of superintendent, a senior officer for good reason. There is also the use of the term defendant as an umbrella term. It has a broadened definition to encompass the person who is in criminal proceedings at various stages at which the question of bail may be considered. And so it's pre-charge, where the person is a suspect, at charge, where the person is formally accused, and after conviction, where the person is a convict. After much deliberation and much exchange, the term was accepted by the committee for recommendation to the Honourable House. Judge is now defined to include a judge of the parish court, and this is as a consequence of the change made by virtue of the Judicature Resident Magistrates Amendment and Change of Name Act in 2016. Madam Speaker, in Clause 3, the application of the Act is set out. There is a table of amendments, and the clause is to be amended to speak to just bail instead of the grant of bail. And this is to prevent any doubt, since bail is not only restricted to the grant, but it also includes the denial of bail. The clause, the Act applies, as I say, to the issue of bail. Clause 3 also clarifies the role of the Children's Court, as well as parents and guardians who consent to be sureties for their children in the determination of the question of bail. Clause 4 speaks to the entitlement to bail, which is set out in the Constitution itself. The clause stipulates that a defendant is entitled to be granted bail by deciding officials pursuant to the power conferred on them by the Act or any other law. Clause 5, Madam Speaker. Clause 5 speaks to when and by whom the question of bail is to be decided. In the earlier version, the entire pre-charge regime was set out in Clause 5. The revised bill has it provided for a little differently. So in Clause 5, for the first time, provision is being made for the period within which a deciding official must determine the question of bail. Also, for the first time, the question of bail may be determined at 3 stages of criminal proceedings. Firstly, as was said before, after the defendant is arrested or detained, but before he is charged. Secondly, after the defendant is charged with an offense. And thirdly, after the defendant is convicted of an offense. Provision is now being made that where there is to be an identification parade, it must be conducted within 120 hours of the arrest or detention of the defendant. If the identification parade is not held within that time, the matter is then to be referred to a judge no later than 48 hours after that 120-hour period has elapsed. And the time lapse is provided to ensure that administrative issues are speedily dealt with and completed. The judge may either specify further time for the conduct of the identification parade period, following which the defendant must be brought before the judge to have the question of bail determined, or he may make such other order as he thinks fit, including in the absence of the defendant, to avoid any prejudicial exposure of the defendant. Most importantly, Madam Speaker, the defendant must be released unconditionally if the offense for which he is reasonably suspected of having committed is not listed in Part 1 of the schedule and he's not charged within 48 hours after arrest or detention. It is not the intention to have a defendant placed on pre-charge bail in every case. Instead, the regime applies in defined circumstances for defined offences set out in the schedule. And, Madam Speaker, as I said before, where the deciding official is a police, the officer has to be at or above the rank of superintendent, and also an officer that is not involved in the investigation or the arrest of the defendant. Clause 6 speaks to consideration for deciding the question of bail. It details the considerations that are to be borne in mind by a deciding official in deciding the question of bail. Where bail is considered by a justice of the peace or a constable, and by constable we mean the police, not the rank of constable. And this really is referring to the grant of bail outside of court, or the consideration of bail outside of court. If after that consideration, bail is not granted to the defendant who is arrested or detained but not yet charged, that defendant is to be brought before a judge of the parish court within 48 hours. If the judge denies bail, the judge must specify the period within which the defendant is to be brought before the court to have the question of bail considered. I have noted in the exchanges with the Leader of the Opposition that he was suggesting a defined period of 42 days. During the deliberations in the Joint Select Committee, we looked at whether or not a time frame should have been set, and felt that since the defendant would be monitored strictly by the court, it allowed the court to closely monitor the period of detention in the event of the denial of bail, and also to monitor the progress of the investigation. And so it is deliberately left in an open-ended way to allow the court to consider the special circumstances of each defendant in each case. In the case of the defendant who has been charged, if the offence is not punishable by imprisonment, bail is granted unless it appears to the deciding official that there are grounds to justify the continued detention of the defendant. For example, where a defendant is being kept in custody for his own protection. And this is a matter that the Constitution itself addresses. In the case of a defendant who is charged for an offence that is punishable by imprisonment, the deciding official shall grant bail unless there is sufficient cause for holding the defendant in custody. And this is what is provided for in the Constitution. And of course, this is after considering the matters which are specified in the clause. And among those matters are the likelihood of the defendant absconding or committing an offence while on bail. Clause 6 also provides that if the offence is capital murder and self-defense does not arise on the prosecution's case, or the offence is murder and it was committed in a zone of special operations, an area under a state of public emergency, or an area within which a cordon is established or a curfew imposed, those circumstances may be considered as sufficient grounds for keeping a defendant in custody. But these are matters that have to be established, and once established, the court makes the determination. In the case of a defendant who has been convicted and who was on bail before being convicted, the judge may grant the application if satisfied that there are exceptional circumstances to so warrant. Madam Speaker, Clause 7 addresses extension of period of release on bail or unconditional release of defendant who has not been charged. This clause empowers a judge to consider an application for the extension of bail granted to a defendant who has been arrested or detained but has not been charged, provided that the bail is not permitted to continue beyond 6 months and an additional period of up to 6 months, or such shorter period as considered appropriate. The Leader of the Opposition, in his exchange with me, queried which of the event the date would run from, whether it's on the arrest or detention or on the bail. It's just a 48-hour difference between the two, but it is meant to be from the date of release on bail, because it's a period of bail that we're dealing with. In considering whether bail should be extended, the judge is required to consider several factors, including the stage of the investigations so far and the manner in which they have been conducted, including how expeditiously they have been conducted, whether further time would enable a charge to be preferred against the defendant, and also the reasons given as to why the defendant has not yet been charged. If after the period for bail has elapsed, including any extension that may have been granted, if the defendant is not charged, he must be released unconditionally. This provision is designed to hold the investigating or arresting officer to account in order to justify a defendant being placed in the pre-charge regime while the case file is being completed to ground the charge. Madam Speaker, I must say that I think the deliberations of the committee were extremely helpful in ensuring that there was a proper understanding of the policy intent, and also that the way the provision was made, it accorded with the letter and spirit of the Constitution. In fact, during the deliberations, members of the opposition requested special assistance in respect of the constitutionality of the regime. And I say thanks to the Attorney General's chambers that assisted, and that part of the deliberation is clearly set out in the report of the committee, which was approved by the House. Clause 8, Madam Speaker, speaks to conditions for release on bail. The conditions that may be imposed on the grant of bail to a defendant at the 3 stages of criminal proceedings are set out. These conditions are aimed at ensuring that the defendant surrenders to custody or appears for trial at the appointed time, does not commit an offense whilst on bail, does not interfere with witnesses, or otherwise obstruct the course of justice. Clause 9 has general provisions relating to bail on a number of matters. These include surrender of the defendant to custody, variation of conditions of bail, subsequent applications for bail, where an application for bail was previously denied, and revocation of bail. Review of bail decision is done at the same level, while an appeal against the decision is to a higher level. One of the innovations of the proposed law is to have the decision of bail reviewed even before you move to appeal in certain defined circumstances. Clause 10 speaks to recording and giving information on decisions concerning bail. And this clause, Madam Speaker, ensures that a record of a decision made concerning bail is given to the defendant, to every person providing surety, where a surety is a condition of bail, and also to the prosecution or the police, where the defendant is not yet charged and is granted bail before charge. Reasons are also to be given for various decisions concerning bail, and these decisions are in respect of the grant or refusal of bail, imposition of conditions in granting bail, variation of conditions of bail, revocation of bail. Madam Speaker, on the list of amendment, you see a form for the record of decisions concerning bail. Inadvertently, this form was omitted from the printed record, but it is here as one of the amendments to be approved. And so a copy of these reasons is to be served on the prosecution and on the defendant or his representative after the decision is made. Must emphasize, Madam Speaker, that providing for prescribed forms is really the way to go. It allows for administrative ease and efficiency and ensures that all defendants are provided with the records in a timely way. And I do believe that where officials are to make decisions, it may always be helpful to prescribe the forms to ensure that matters of record can be kept in standard way and be provided to affected parties. In the case of a defendant who is unrepresented, he must be informed of the procedure for review and the right of appeal by the deciding official. And like I say, Madam Speaker, the prescribed form was inadvertently omitted, but is now on the list of amendments, and the amendments really relate to including that form in the bill. The timeframes that are set for practical reasons. Moving to Clause 11, this speaks to review of bail decisions. Another innovation. Bail decisions are required to be reviewed by a judge of the court in the manner and within the set time in the clause. A bail decision is to be reviewed on the defendant's first appearance before the court. And Madam Speaker, this will ensure that any bad decision, bad in quotation marks, taken on bail out of court can be reviewed by the court. Review of a bail decision is also allowed on the application of the defendant where bail was denied, on the application of the prosecution where bail was granted, or where there was a failure to impose a particular condition. The review process requires that a change in the circumstances must have occurred since the previous decision concerning bail was made, or that new facts have arisen that were not available at the time of the previous decision. And this is to ensure that judicial time is well and properly used, given the number of cases before the court. It makes no sense to merely repeat an application when there is nothing new that would change a decision in respect of the application. So this allows for issues to be conveniently addressed where circumstances change or new facts come to light. Clause 12 deals with appeal from decision of the judge. The right to appeal and the appellate process are set out in this clause. The defendant may appeal a bail decision to the Supreme Court in chambers or the Court of Appeal in chambers, as the case may be. The prosecution may also appeal to a judge of the Court of Appeal in chambers where the defendant is granted bail by a judge of the parish court or the Supreme Court. The powers of the court of the judge in chambers on appeal are to affirm the previous decision, grant or refuse bail to the defendant, or vary or remove any condition of bail. Madam Speaker, turning to Clause 13, this deals with absconding by person released on bail. A defendant commits an offense, the offense of absconding, if he fails to surrender to custody, or despite the fact that he has a reasonable excuse for failing to surrender to custody at the appointed time, he fails to surrender as soon as is possible thereafter. You know, Madam Speaker, the experience in the COVID actually helped us with this provision because so many things happened during that time, which made it clear that sometimes there may be omission, not with a view to break the law or not to honor obligations. And so where eventualities arise, we provide for the next earliest opportunity for a defendant to honor the obligations and not run afoul of the law. It is important to note that the offense of absconding is punishable on summary conviction before a parish court to imprisonment for a term not exceeding 5 years, or on conviction before a circuit court to imprisonment for a term not exceeding 7 years. If the defendant is convicted of the offense for which he was released on bail, and thereafter absconded, he is to serve the sentence for the offense of absconding after serving the sentence for the offense for which he was convicted. Madam Speaker, turning to clause 14, which addresses liability to arrest for absconding and breaching conditions of bail. A warrant may be issued for the arrest of a defendant who either fails to surrender to custody or absconds after surrendering to custody. A defendant may also be arrested without a warrant if the constable has reasonable grounds for believing that the defendant is not likely to surrender to custody or is likely to breach any conditions of bail, or if there is reason for suspecting that the defendant has either breached a condition of bail or has committed an offense whilst released on bail. Where the defendant is arrested, he must be brought before a court within 48 hours or the next sitting of the court, whichever is sooner. And that court may revoke his bail and remand him in custody. Clause 15 deals with bail with surety, where the defendant is required to surrender. To provide a surety as a condition for bail, the factors to be considered by the deciding officials in determining the suitability of a proposed surety are set out in this clause. And these relate to the proposed surety's profession, occupation, trade, already in the law, character and previous convictions, proximity, this is new, whether of kinship, place of residence or otherwise to the defendant, and the capacity to supervise the conduct of the defendant and to ensure the defendant's appearance in court when required. The provision also details the procedural requirements to be satisfied by a surety and brings clarity and certainty to those procedural requirements. It is an offense if a person, in making a declaration under this clause, makes a statement he knows to be false. He is liable on conviction to a fine not exceeding $3 million or imprisonment for a term not exceeding 3 years. Provision is made for the defendant to act as his own surety if he has been offered bail but is unable to provide a suitable surety or is not likely to be sentenced to imprisonment, and also where the deciding official is satisfied that the defendant is not likely to abscond or commit an offense whilst on bail. Moving to clause 16, this provides for forfeiture of security or recognizance. The court may order the forfeiture of any lump sum up to the full amount of the surety, the security that is. This order may be made in the case of a defendant who provided a security to secure his surrender to custody as a condition of bail, but he either fails to surrender to custody or where the defendant is a child and the surety is the parent or guardian of that minor. The child breaches any other condition of bail. Clause 17 speaks the release of surety or refund of payment. It provides for the circumstances in which the surety may be released from obligations. They include where the court grants a release on the application of the surety, where a nolle prosequi is entered regarding the defendant for whom this surety was provided, where the matter against the defendant is dismissed, as evidenced by a certificate of dismissal from the court. And just to say that many people are dismissed by the court, but they do not normally follow up in getting the certificate of dismissal until they require a police record and they see something pending. But there is a standard form of a certificate of dismissal, and I say to everyone, ensure that where your case is dismissed, that you get this certificate of dismissal. Also, the surety may be released where the defendant is acquitted or convicted and the surety is released by the court. The surety is to be refunded any amount paid. However, if a fine is imposed, it may be deducted. The amount of the fine may be deducted if the surety consents. Moving to clause 18, which provides for prohibition which prohibits any agreement to indemnify a surety. Under the clause, it's an offence for a person to offer or agree to indemnify a surety against the possibility of loss arising from the absconding of the defendant. The offence is committed irrespective of whether the agreement is made before or after the person agreed to act as surety, the person is to be indemnified becomes the surety, or the offer contemplates compensation in money or money's worth. The offence is to be punishable by a fine not exceeding $1 million or imprisonment for a term not exceeding 1 year. In clause 19, provision is made that property is not to be used concurrently as consideration for surety, but notwithstanding, prior approval of the court may be obtained where property approved as surety, security for acting as surety is to be used for multiple defendant. In considering whether to grant approval, the court must assess the sufficiency of the value of the property in relation to the securities concerned. An offence is committed where a person contravenes the clause, and the offence is punishable on summary conviction in the parish court by a fine not exceeding $1 million. Clause 20 deals with the declaration of bail centres. The minister is empowered to declare any facility to be a bail centre to facilitate the attendance of child offenders released on bail. The declaration is made by order and it must be published in the Gazette. The clause also provides that any facility that was a bail centre under the Bail Act 2000 is deemed to be a bail centre under this Act. Clause 21 provides for the power to make regulations by the minister, generally for giving effect to the provisions and purposes of the Act, subject to affirmative resolution. The minister is empowered to amend any of the schedules or any monetary penalty imposed by the Act by order, subject to affirmative resolution. Clause 22 speaks to the repeal of the Bail Act 2022. Clause 23 addresses consequential amendments, and these include to the Constabulary Force Act, the Judicature Parish Court Act, the Justices of the Peace Jurisdiction Act, the Larceny Act, and the Towns and Communities Act to ensure consistency with this Act. There are schedules. The first sets out the offences for which bail may be considered where a defendant is arrested or detained but not yet charged. Part 2 of the first schedule sets out the offence for which an application for bail after conviction cannot be granted and for which the deciding official must be a judge. The second schedule sets out the form of the notice to be filed by a defendant who intends to appeal against any condition of bail imposed where he's arrested or detained but not yet charged and is granted bail. Third schedule, there is a change. The third schedule will have the record of bail decisions, and that is on the amendment list. And then we go to the consequential renumbering with the other schedule, setting out persons exempt from acting as surety, the form of the statutory declaration to be made by the surety, the form of the declaration as to the surety's identity, etc. The Leader of the Opposition queried, and I thought quite interestingly, whether that should be an ineligibility or an exemption. What is currently in the Bail Act is an exemption, and the intention was to keep it in that way. So why we didn't go for ineligibility, for example, is where one of the exempt persons may, God forbid, have a personal family matter, and you may choose to deal with that separately from the other matter. But also, in where you are exempt, should you choose to forego the exemption, the court will take into account the fact that you are exempted and make a decision that is appropriate in the circumstances of each case. And that, Madam Speaker, takes us through this bill. I do not believe that we have any contentious issue left after the intensive and extensive review that was done in the Joint Select Committee, and at which every effort was made to answer the many issues that came from the opposition at all angles, even after I thought they were addressed. But thankfully, at the end of the day, we were able to agree on the report that came to the House, which was approved and which reflect these amendments in the revised bill. I will pause at this time.
Thank you, Minister Malahoo Ford. You efficiently used up your entire 45 minutes. Just about. Opposition Leader.
Thank you. Thank you, Madam Speaker. And I thank the Minister for her presentation and the dialogue that we have been having today on some issues which I had raised. I think the Joint Select Committee process was absolutely vital to taking us to where we are now with this piece of legislation. The new bill that was tabled last week, replacing the one that was originally tabled, incorporates the deliberations of that committee to the extent that the committee members generally were willing to sign the report of the Joint Select Committee, indicating broad agreement with the bill in the form that it now takes. I was not on the Joint Select Committee, so I reviewed the bill with a fresh pair of eyes, so to speak. And one concern I have about the bill is that it is not an easy bill to navigate. It is an elaborate piece of legislation, and I think that it could have been presented in a way which would be easier for practitioners and laypersons to follow, perhaps by breaking out into different parts of the Act, those that are dealing with the pre-charge bail and the arrangements around that, and the situations where persons have been charged and so on. The way it is done, there's a lot of cross-referencing and interweaving of provisions, which requires significant skill to actually arrive at an understanding of what is intended. So that is a concern I have, because something that's dealing with a fundamental issue like bail is a piece of legislation that is going to touch and concern many, many Jamaicans in the years ahead. And so it is a type of legislation which would benefit from being presented in the clearest possible format. This is not a substantive criticism, it is one of presentation, but I think it's important for me to mention it, because as I've said, I did find it required a high level of intense focus in order to come to grips with the way in which it is structured, especially looking at it for the first time. The minister has been living with it for many months, probably years. So I dare say for her, it may look like a walk in the park. But for somebody who is approaching it fresh, it is not the easiest bill to navigate. I made some specific comments on the bill in a submission that I sent to the minister yesterday. She had requested that I do that in advance of the sitting, and I was happy to do so. And as soon as I'd finished going through it and prepared the memo, I sent it to her so that she could have an opportunity to look at it and also to to share it with her technical team. I'm aware that some of the points, most of the points that I'm making may not be taken on board for one reason or another, but nevertheless, I think it's important for me to go through them, if only for the record, because it may be that as this legislation is applied in practice, it may come before the courts. There may be potentially a challenge to aspects of it because it's breaking new ground, especially in relation to the pre-charge aspects of it. And there may be other provisions that people struggle to interpret, and they can refer to Hansard perhaps to get some clarity insofar as, you know, if I have raised an issue here which is addressed a particular way by the minister, then they will at least know what the government's intention was in relation to that provision. So I think it's important that I go through it. I begin, Madam Speaker, with Clause 5 of the bill. And I speak to Clause 5, 2B1. Now, Clause 5 is a sort of introductory provision in a sense, because it establishes which provisions or which offences are amenable to pre-charge bail and which are not. And then 5 goes on to say who the deciding official must be or can be for making decisions in relation to bail, in relation, whether it be in a pre-charge situation or a situation where a person has been charged, or indeed where a person has been convicted. So, as the minister has outlined, there's a first schedule which is in 2 parts, and part 1 has a list of serious offences that are offences which may give rise to a pre-charge grant of bail. And I think to the layman there's a sort of confusion that may arise, because if these are serious offences, why are we talking about granting bail before the person's charged? And the reason is that with the grant of bail may come the imposition of conditions that the defendant, who in this particular aspect of things where it's a pre-charge situation will be somebody who's not yet charged with an offence, will nevertheless have to comply with conditions of their bail. So they will be under restrictions if conditions are imposed, restrictions on their liberty in accordance with what the Act allows by way of conditions. So the first schedule, part 1, has a list of offences where that can happen, where you can be granted bail before charge, having been arrested, but subject to conditions. And if you look at the list of offences, they include things like murder, serious offences under the Offence Against the Person Act, certain offences under the Dangerous Drugs Act. And I must say one of them in particular that I'm not happy with, which is Section 7B of the Dangerous Drug Act, which is cultivating, selling or dealing or transporting ganja. This is not export, but domestic transactions in relation to ganja, including cultivation. I don't think that this pre-charge regime should apply to that, given where we are in the reforms in relation to how we deal with ganja, and the fact that ganja is now something which can be regulated, can be sold, can be exported, and indeed consumed lawfully. So I'm not happy with the inclusion of that provision in Part 1 of the first schedule. Now, in relation to Clause 5.2, what I think is significant is that in relation to somebody who has been charged, if that charge is in relation to anything other than an offence listed in Part 2 of the first schedule, then the deciding officials include constables and justice of the peace. Now, and judges. Now, Part 2 is a narrower subset of serious offences than Part 1 of the first schedule. So whereas Part 1 has in its list 17 different statutes are referred to and offences arising under several of those, Part 2 only has 4. So immediately you see that Part 2 is a much narrower universe than Part 1. Part 4 only lists offences really under 4 statutes, whereas Part 1 has 17 statutes. I would also mention, I noticed that in Part 1, Item 15, which is dealing with the Anti-Gang Law Act, only 4 offences are included in Part 1 under the Anti-Gang Act, and I wasn't sure why it wasn't treated in the same way as the Terrorism Prevention Act or the Lotto Scamming Act, the Law Reform Fraudulent Transactions Act, where all offences under that act are subject to the pre-charge regime. Under the anti-gang law, you've only chosen 4 sections out of the act, and there are several other sections that have serious gang-related offences. So I was a bit perplexed about that. But the point I am making here is that in relation to offences for which somebody is charged, which are not on Part 2, not listed in Part 2, which is a smaller list, you will have many serious offences which are not in Part 2. Part 1, as I said, encompasses serious offences from a much wider list, and there are indeed serious offences which are not in the first schedule at all. What we have in this regime is a situation where a constable, which includes really, I think, any member of the police force, from the rank of constable up to commissioner, they are all constables, as I understand it. So you could have decisions around bail conditions being made by a very junior member of the force, somebody who is at the lowest rank in the force, a mere constable. And I was concerned as to why, in imposing conditions on the liberty of a subject, the deciding official, when it comes to the imposition of conditions, if it's somebody below an officer ranking, ought not to have the sign-off of a more senior officer in imposing those conditions. I was concerned about leaving such a... Sorry? Yes, so that is in the pre-charge situation. That's where you're getting a bail decision on the 5.1a. But I'm talking about on the 5.1b, which is where you've been charged. I move to Clause 6 of the bill. Clause 6 provides that where bail has been denied by the parish court to a person in custody who has not been charged, so this is a pre-charge situation and the parish court has denied bail, and the minister spoke to this, I am of the view that there ought to be some specified maximum period that the person, within which the person must be brought back before the court for bail to be reconsidered. It's at large presently, and the minister said that a decision was made that it could be left to the discretion of the judge. But we're talking about somebody who has not been charged, but is denied bail. And there's no outer limit to say they must be brought back before the court. Yes, but there's no outer limit as to when that time can be fixed. It could be a year. Well, I don't know. Point me to where the limit is. If there's a limit, please point it to me, because I didn't find it. And it sort of bothered me, which is why I had suggested a 6-week maximum at the end, so that if you're denying somebody bail and they haven't been charged and they're still in custody, then they have to be brought back before the court. The judge can't go put a 6-month period or a 18-month period if they don't like the person, or the person is somebody who they feel needs to be held in custody for a long period of time. This person should be charged if they're going to move forward. And I think if you're holding somebody in custody for long periods of time without charging them, there should be an outer limit. And I raise this because constitutional issues are going to be engaged in some of these provisions. And I think to the extent that Parliament puts some limits around these discretions, that would help to preserve the constitutionality of those provisions in the bill. I move to Clause 7. I had asked the question as to when the 6-month... Now, Clause 7 is dealing with somebody, again, who has been arrested or detained but has not yet been charged, but is released on bail. So this is pre-charge bail now. And then it says that if 6 months has elapsed without the charge being preferred against that person, then you have to release them unconditionally. So you have 6 months under this regime within which to charge somebody who has been released on bail but is not actually charged yet. And I'd ask the question, well, does that 6 months begin from the date of arrest and detention, or from the date of release on pre-charge bail? And I think that should be clear, should be clarified. The minister says, well, it's only 40 hours, the commencement period is only 48 hours different, whether it's, and that assumes, of course, that the act is administered in practice in accordance with the letter of the law. That may not always be the case, right, when it comes to holding people in detention. So I would like that to be clarified. And the minister has indicated it, the 6 months begins from the date of release. Yes, but I think it should say that, if that is what's intended. In Clause 7.2, it speaks to, there's a qualification to the 6-month period after which a person must be released unconditionally if not charged. And that qualification is that it can be extended for a further period of 6 months, which would take it potentially to a year of being released on bail but not having been charged. And that requires an application to the court, to the parish court, for that further extension to be made. But it talks about the release on bail may be extended for a further period of 6 months. So 7.2 is specific as to the period of the additional extension. It's a period of 6 months. And I think it ought to be worded for a further period of up to 6 months, because the court may feel that 6 months is too long as a further extension. It may be happier imposing 60 days, for example. And when one looks at Clause 7.4, it actually says that the judge may specify a period of 6 months or such short a period as the judge considers appropriate. So even in 7.4, it contemplates that the judge may grant an extension for less than 6 months. And I just think the language in 7.2 and 7.4 should be made consistent. One is suggesting the period is 6 months of the extension. 7.4 is suggesting that it's a flexible period, not exceeding 7 months. I think that should be consistent. Yeah. I move to Clause 8. Now, this is 8.2. Dealing with the conditions that apply to pre-charge bail. And the conditions that may exist are set out in 8.2 in 5 paragraphs. A, B, C, and D. Now, A, B, C, and D are those where the deciding official is not a court. In other words, where the deciding official is a constable, i.e. a police officer, or is a justice of the peace. And E applies where the deciding official is a court. And E is broad and says, such other conditions as appear to the court to be necessary. So, in a sense, it's at large under E what type of conditions the court can impose on somebody who is being granted bail before being charged. That's another area of potential challenge, I think, because it suggests that the court is at liberty to fashion its own set of restrictions without any guidance from the legislature on this area. But the point I was going to make was that A, B, C, and D, which apply where the pre-charge bail is granted by a constable or a justice of the peace, does not include in the list a provision which I'm aware is commonly imposed in practice in areas which are hotspots, where persons are required to stay out of the community while they're on bail. Often the situation may be that the victim lives in the community, witnesses live in the community, the cohorts of the cronies of the defendant live in the community, and it is desirable to ensure that that person is not able to come into the community. Now, that is not permissible unless you go to the court for making that order. That is not something, that is not a condition that the JP or the constable can impose. And I wasn't sure, given the utility of that provision, why it wasn't there. Also, and this is for my own personal edification, as you have a lot more experience in the criminal courts than I do, but where it talks about a requirement to provide a surety or for payment of a bond in such amount as may be specified, and that phrase is repeated, yeah. But is there no guidance as to the limits, minimum or maximum? I see. Yeah, I know, but since we're repealing and replacing the act, it occurred to me that there ought to be some guidance around what principles apply in fixing the amount of the bond that must be paid to access bail. Yes, I see that. But this is somebody who has not been charged. They may not have a surety who's willing to stand surety for them. So the principles that would govern how the bond payment is to be quantified, I thought ought to be something that is prescribed or whatever. But I'm not making a big issue of the point. I just think it's odd that it's left at large. Typically, things like fines and so on have some limit unless it's in the Supreme Court. So I move to 8.7. Yeah. This was a drafting point. I just felt that where it talks about any one or more of the conditions specified in subsection 9 or 10, when you look at 9, the most important, rather if you look in 10, the most important provision is perhaps the catch-all, which is, it says, such other conditions as appear to the deciding official to be necessary. So those conditions are not actually specified in 9. Rather, the official is empowered to determine what the conditions should be. Yeah, I just thought that the language could have been more facilitating of that provision, rather than saying it has to be specified. Yes. Correct. Exactly. That was what I had in mind. Then one second, please, Madam Speaker. Now, this is another point which I think goes to the potential constitutionality of the bill. In 9 and 10, 8.9 and 8.10 flow from clause 8.7. And 8.7 is dealing with a defendant who is charged or has been convicted of an offense and is being granted bail. So 9 and 10 are not relevant to the pre-charge situation. This is where somebody has been charged. And 10 says the deciding official may require the defendant who is granted bail to do any one or more of the following. And so this is where the conditions are elaborated. And it goes on to say, comply with such other conditions as appear to the deciding official to be necessary. So, to my mind, that is a very broad discretion that's being given. Yeah. But I noticed, for example, that in the pre-charge situation, that broad discretion was limited to the court. Yeah. Whereas in a charge situation, that broad discretion is being given to a constable. And that's my challenge. Because 11 has a list of where the deciding official is a court. The 11 says that these other conditions that appear to be necessary to the deciding official, where the deciding official is a court, can include 3 things: surrender of travel documents, imposition of a curfew, or the wearing of an electronic tracking device. But where the deciding official is not a court, then the conditions are at large. Well, that's how it's worded. 10C. So the situations which can only be imposed by a court are listed in 11, which is A, B, and C. So the deciding official who is not a court can't do A, B, and C, but they can do anything else. I'm talking about 10C, 810C. 810C on page 14. And its interrelationship with 811. That's what I'm talking about. And it concerns me that there's this broad discretion being given to a deciding official who's not a court. And that isn't being given in the earlier provision in 8, which is 8.2, which is dealing with the pre-charge situation. But this is dealing with the charge, the situation where someone's been charged, and the conditions of bail are being identified. And 10C allows a kind of open universe of what conditions can be imposed by the deciding official, other than the ones that are listed in 11, which can only be imposed where the deciding official is a court. But 10C is dealing with other situations where the deciding official is not a court, and seems to be completely open as to, and especially when this deciding official may be a constable. It's a very open-ended thing. So given the constitutionality of the issues, I'm just bringing it to your attention and Hansard's attention that I have a concern with how broad that is in that scenario. I move to clause Yes, I wasn't sure why. I'll move to clause 9. I'll move to clause 9. This is just a drafting point, I think, Minister. But I wasn't sure if this was more than a drafting point, which is why I've raised it. 9.5 on page 16. And this is dealing with applications to vary the conditions of bail. And it's saying that that application to vary the conditions of bail that were imposed shall be determined as far as practicable by the original deciding official. Fair enough. So if you're seeking to vary bail and the deciding official had imposed a particular condition, you want to vary it, you go back to that deciding official and they can consider it again. If they're available. If they're not available, it says that the application may be determined by a deciding official of the same category as the original deciding official. And I wasn't sure if that was intended to mean that it can't be determined by any other category, especially a more senior category. Mm-hmm. Well, this is suggesting that you go back to somebody in the same category. So, for example, if the deciding official was a constable, you go back to the police. But supposing you couldn't go back to a JP, for example. But you couldn't, if the police made the initial decision and that police isn't available, you couldn't go to a JP, or you couldn't go to the court. Yeah. So what you're telling me is that it is intended to mean that you can only have the application for variation being heard. If the deciding official isn't available, you have to go, you can't go to somebody with a higher. Yes, well, the appeal is another story. All right. I'm glad to see that we're prescribing the very important record of decision and reasons.
Members' time for speaking has expired. Also, House Leader, in about 2.5 minutes. 2.5 minutes. We will be at 7:20.
Madam Speaker, the members' time for speaking having expired, I beg to move that he be given.
Enough to complete. I'm nearly done.
Yeah.
I don't want to play 5.
Given the fact that we have the 7:20 coming up, and we then would have to ask permission for the House to sit beyond 7:30.
Yeah. Well, you can do that.
If there's a kind timeline that you could express, we would be 10 minutes, 15 minutes. 10 minutes, Madam Speaker. The members' time be extended by 10 minutes.
Question is that the members' time be extended by 10 minutes to allow for the completion of his contribution. House Leader, are we going to ask for the extension of time in 2 minutes? 1.5 minutes.
Yes, Madam Minister, the new third schedule. I was not sure where this is being introduced in the bill. The new third schedule that sets out the form, which is something I had written to you about, and I'm glad that that was already in the works. Yes, but where in the bill does it make reference to the third schedule? Well, I see delete the third schedule. A lot of those are, okay. Okay, all right, fine. I'm not sure why it says Regulation 10. What is that? Beside the word third schedule. I don't know if that's just an oversight. Yeah. I'm not sure what that's there for. All right. I move to Clause 10. We have a regime for should be Section 10. Section, all right. Should be Section 10. Okay. There's a regime in 10.1 that deals with when the record is to be made and how
Madam Speaker, the time being 7:20, I ask that the House be allowed to sit beyond 7:30 to complete the business of today. But just before you respond, Madam Speaker, I urge the debate to move along in a far less conversational and interactive tone, so that we could finish this side of midnight. Madam Speaker.
The question is that the time being 7:20, the House be allowed to sit beyond 7:30 to complete the business for the day. Those in favor? You could have voted against. Those against? Those against? The ayes have it.
Thank you, Madam Speaker. So, in relation to the record and the service of copies of the record on the defendant and others, it says that it must be done as soon as practicable after the record is made. In relation to the reasons that are required for the decision, it says that those are to be served within 48 hours after the decision is made. I asked the minister about this, and she said it's one procedure: the making of the record, the giving of reasons, and the serving. I just don't understand why there are two different time frames applied to both. It should just synchronize as one regime if it's one procedure. So I think that should be clarified. Yes, but one says, you know, as soon as, one says 48 hours, one says as soon as if it's two different things. I don't see why that should be. I move on to clause 10.4a, which speaks to the need for a copy to be served on the prosecution. Now, I noticed that in 10.1, in the Roman numeral 3, at the bottom of 10.1, it says that the service is on the record, a copy of the record is on the prosecution, or in the case of a defendant who has not been charged, to the police. Whereas the reasons, it says, in relation to has a prosecution but doesn't have that formulation, or in the case of a defendant who has not been charged, to the police. And I wasn't sure why there are the two different formulations there, one in relation to the prosecution and one well, it's not immediately obvious to me. Where you're required to give reasons. I mean, it seems to apply across the board. But anyway, it does seem odd that one contemplates being served on the police instead of the prosecution. You haven't been charged. And in the other, the reasons, you know, which would apply where you haven't been charged as well. It only mentions the prosecution. I wasn't sure why. 11.1 is an important provision, and I'm not satisfied with the answer I received. So I'm going to just mention it. This is dealing with the review of bail decisions, and it says that a decision on bail by a constable or a JP shall be reviewed by a judge of the court having jurisdiction to try the offense concerned. And it says A, on the defendant's first appearance in court in relation to that offense. Now, what I'm in a situation where the matter is at the parish court stage, there may need to be a committal proceeding, for example. The offense is one that's triable in the Supreme Court. The words in 11.1, the opening words, suggest that the review has to be done by the judge who has jurisdiction to try the case, which would not be the judge of the parish court. So I don't know how that works with the requirement that on the first appearance in court, the review is to be done. It needs to be tweaked. Thank you. I'm glad that you follow me because I didn't understand the technical response. Agreed. Yeah. I have a few more minutes. 3 more, I think. The other thing I wanted to say is this. In 11.2, it speaks to the grounds of review. And the grounds of review would be that there's been a change in circumstances or facts applicable that were not, which were not available for. And this is a situation where, on the review, and I'm focusing on the situation now where the prosecution may want to have that review done. The prosecution is seeking a review to be done, right? Under 11.1c. The prosecution may be of the view that the deciding official's decision is just wrong. There may be no new facts. The circumstances may be the same, but they may feel very strongly that this person, I don't know why they are not able to have it reviewed in a situation where they feel strongly that the decision is flawed. So I was questioning that. And then I note that an appeal by the prosecution to correct the decision doesn't seem possible if the deciding official was a constable or a JP, as the ability to appeal under 12.2 only applies if the deciding official is a judge. If you look at 12.2, it says that where bail is granted to a defendant by a judge of the parish court or a judge of the Supreme Court pursuant to this act, the prosecution may appeal. But where bail is granted by a deciding official who's not a court, where is the jurisdiction? Where is the appeal? Where is the provision that deals with that? Because 12.1 is dealing with the defendant's right to appeal. But the 12.2 is dealing where the prosecution can appeal. So if the review isn't possible on the basis that the original decision was flawed, and you can't appeal, then you're stuck. The prosecution is stuck. And I think that's a lacuna which needs to be fixed. And the last point I wish to make is in relation to 15.2 on the word exempt. And it has been stated by the minister that that's language in the current act, the use of the word exempt. Persons are exempt. It just, when you're exempt from something, it means you're not required to do it. The wording suggested to me that what was really intended was to say that these persons are really ineligible to provide surety. We're talking about who can stand surety for a defendant. So, for example, the list includes members of parliament. We are exempt, for example. And the Governor General is exempt, and members of the judiciary are exempt, which one would expect, right? Now, to my mind, they should be ineligible. Not that they're exempt and they can decide to do it if they wish. You don't want a judge being granted bail because he decides or she decides to waive the exemption. Those are categories of persons who should not be involved in giving surety for persons who are charged with criminal offences. And certainly for us in Parliament, being prohibited from doing it is a good thing, so nobody can come tell you them why you bail them or stand surety, right? Sorry for the vernacular, ma'am. So I think the word exempt is the wrong word. And I think that the word ought to be shall not. I think it should be worded the persons listed in part 1 of the 4. All right. You say it's not the wrong word. I'm suggesting a different approach. If you say so. If you say so. Because to be honest, I think it's a wrong word, and I'll tell you why I think it's a wrong word. When you say, I'm exempt for acting as surety, I don't have any obligation to be surety, so I can't be exempt from it. You're only exempt from something which you would otherwise be required to do. Yeah, but I'm just saying the language, I'm glad my time is up, because I could argue this point for long. So, Madam Speaker, as I said, I don't know to what extent these issues will be entertained by the minister. I think that some of them are very important issues, and I think they go to making the bill a stronger bill, a bill that can withstand constitutional scrutiny. I'm not saying even if my points are addressed that it will, because we're forging new ground. And once you talk about persons being released on condition when they haven't been charged, the courts are going to scrutinize that in a very officious way, and it will be tested. But I think the amendments that I have proposed that were directed to that particular issue ought to be considered, because they will make it easier for the court to find that the legislature has directed its mind to those issues and put appropriate checks and balances in place. And so I commend them to you, Minister, and I thank you for listening, and all the best. Thank you very much, Madam Speaker.
Minister.
Madam Speaker, we really are getting a taste of what it means to have the Parliament work long in the day to pass laws. Let me thank the opposition leader for his comments, just to say that the points raised by the opposition leader are not constitutional points in the strict sense, important as they are. Because one of the things that had to be clarified is that the exception to liberty that is engaged in this matter is an exception that speaks to what happened when a person is suspected of having committed an offense. And the Constitution at 14 sets out a scheme that we had to navigate and look at the case law around. And a lot of time was spent. So it's important for it to be said and repeated that not every concern that is raised in respect of differences and different approach means that a constitutional issue arises. Huh? So that. Madam Speaker, in respect of Clause 5, in respect of the drug offences that the Leader of the Opposition said he had a little issue with, the inclusion of that offence under those offences under the Dangerous Drugs Act is deliberate because the data we worked with showed a link between the guns and the drugs and the trade in that regard. So matters that are now legal for medicinal or therapeutic use, those are not the offences that are included here. It's those matters that remain prohibited and for which there is good cause for concern. The deciding official is that issue. The deciding official is not an investigating officer or an arresting officer. And the reason why we have it like that is that not all stations have high-ranking officers. So we didn't indicate for the charge regime that the officer had to be at the rank at or above superintendent, because when we check practically with how assignments are done to police stations and outstations, not all of them have those high-ranking officers, and you wouldn't want to stipulate a rank and then makes it difficult administratively for the question of bail to be considered at a station where you do not have a superintendent or even an inspector. Some stations, the highest rank is a sergeant of police as the sub-officer in charge. The issue around the detention, again, the period for detention, this matter was deliberated and it was felt in all of the circumstances. The court is best placed to determine the period on the peculiarities of the case. All things turn on the case in its own circumstances. The point about aligning clause 7 sub 2 with clause sub 4, I'll just be guided by the CPC in respect of that. And in respect of clause 6.2e, the conditions to be imposed out of court are deliberately fixed to invite no abuse, to limit, to have no discretion in the matter, and the court is given the greater latitude as courts know how to better assess those issues. It seems as if the Leader of the Opposition has an interpretation that's a little off in respect of clause 8, Madam Speaker, and I think perhaps it's a reflection of his minimal familiarity with the criminal courts. The interpretation at clause 8 sub 10 and 11 seem to be really way off. I did note, however, his comment about the structure of the bill, and it's always the desire to make bills structured in a user-friendly way. Perhaps it's my own familiarity with the criminal law. I didn't find it as difficult, but the structuring of the bill really is a matter that is left to the Chief Parliamentary Counsel. Bear in mind that legislative drafting is a technical skill. Many of us think that we can do it because we may be able to write documents, but there is a rhyme and a reason to structuring a bill in a particular way. So at this stage, I'm not sure if I can assist in a restructure, because we did restructure the bill after the during the joint select review phase. Madam Speaker, let me thank the Leader of the Opposition. I know it was a little difficult for him to say that he no longer has any issue, but I note that a critical aspect of the bill covers an area that we have been talking about in the enhanced security regime that is to be built out. And the Leader of the Opposition, out of the context of the Honourable House, did speak to a matter where government and opposition seem to be on the same page in respect of that. The only difference now is that he's asking for a 42 days time to be fixed. And after the review and the deliberations, the view is taken that the interest of justice would be better and even best served by leaving that time frame to the court on a case-by-case basis. So, Madam Speaker, on that note, I ask for the bill to be read a second time. So, the debate is concluded on the bill, and
Thank you.
Ask
Thank you.
that the bill be read a second time.
The question is that the bill be read a second time. Those in favor? Those against? The ayes have it.
A bill entitled An Act to Repeal and Replace the Bail Act and to Provide for Connected Matters, read a second time.
The House will now resolve itself into a committee of the whole House to consider the bill clause by clause. Minister, other than the amendments that were tabled here or circulated, do you have any additional amendments coming out of the debate?
I'll just seek your kind indulgence to just have a little exchange with the CPC. There is a request to align clause 7.2 to clause 7.4. May not be strictly necessary, but I do not believe any harm would be done, since the intention is to have the period go up to the 6 months in that case. And in respect of clause 8.7, really minor to change in, where it says conditions specified in subsection 9 and 10, to under, just to reflect the fact that at subclause 9, 10E, it speaks to compliance with such other conditions as appear to the deciding official to be necessary. A suggestion was made in respect of clause 8 to include as a condition that the defendant stay out of the community, a specified community or geographical locale where witnesses or the victim may be located, to minimize any likelihood and risk of reprisal. I think it's a good suggestion, and I'd like to take it on board and ask for the CPC to include.
Minister, just to make sure we're on the same page, other than the amendment submitted, it will be section or clause 7, 7 subsection 2, 7 subsection, no, 4 being aligned with 7 subsection 2, 8 subsection 7, and that's the extent of the additional amendments that you will be taking a look at.
Yes, Madam Chairman, I would say we could just defer clauses 7, 8, and 7 and 8.
7 and 8.
11. May I just seek your kind indulgence, just to confirm?
No, so what I was going to do in the interim, Minister, is
We won't be long. There isn't much to do for us to take it through committee stage. Just Madam Speaker, while you confer with the clerk, may I just crave your indulgence to just walk up to have an exchange with the CPC.
Members, if it is okay with you, you're ready? Okay. So the suggestion is, Minister, when you take your seat, could you please let us know what the additional amendments are outside of what was previously circulated? The idea is to take the entire bill along with the amendments previously circulated and any additional amendments you so choose to add at this stage.
So, Madam Chair, for the record, in respect of the amendments to be taken, circulated we have at clause 3, that remains. Then we have one being added at clause 7, sub-clause 2, where we would delete the words period of and substitute therefore the words period not exceeding.
Yes, you may continue, Minister.
The next one is at clause 8, subclause 7, where we would delete the words specified in and substitute therefore the words specified under.
Therefore specify under.
Under. It's really changing into under.
Okay.
The proposed amendment to clause 10 as set out on the sheet remains. New amendment at clause 11, subclause 1, inserting next after the words offense concerned, the words before which the defendant first appears, as the case may be, in parenthesis. As the case may be, in parenthesis. And that addresses the concern raised by the leader of the opposition and brings clarity to it. The amendments set out at clause 12 remain. Clause 15 remain. We're doing an amendment to what is on the amendment sheet at clause 17 to read in the marginal note and subsection 1, delete the words, we just add and subsection 1. So it should read, in the marginal note and subsection 1, delete the words fourth schedule and substitute therefore, in each case, the words fifth schedule.
Noted, Minister.
The proposed amendment to the third and fourth schedule remain as circulated on the amendment sheet. New third schedule, there is an amendment where you see the word regulation to the right of the heading, third schedule, that word regulation is to be deleted and substituted with the word section. So instead of regulation 10, it would read section 10. Those are the, Madam Chair.
Thank you very much, Minister. We'll allow the clerk to just check off and verify the total number of amendments as we have it. However, in the interim house, committee members, I would like to put clauses 1, 2, I'm good. I would like to put clauses 1, 2, 4, 5, 6, clause 9, clause 13, 14, 16, 18, 19, 20, 21, 22, and 23, which have no amendments to the House. Those in favor? Those against? The ayes have it. I would now like to put clauses 7, she made a change. No.
Clause 7 has an amendment to two
Just read the new amendment in.
We delete the words period of and substitute therefore the words period not
Minister,
exceeding.
We have the amendments that have been made. So I would like to put the amended clauses, clause 3, clause 7, clause 8, subsection 7, clause 10, clause 11, clause 12, 15, 17 as further amended to the committee. Those in favor of the amendments being adopted?
Aye.
Those against? The ayes have it. I've not reached the third schedule yet. I now put the first schedule. Those in favor? Those against? The ayes have it. I now put the second schedule. Those in favor?
Aye.
Those against? The ayes have it. I now put the third schedule as amended, as included here. Those in favor?
Aye.
Those against? The ayes have it. I now put the fourth schedule as amended. Those in favor?
Aye.
Those against? The ayes have it. I now put the title and enacting clause. Those in favor?
Aye.
Those against? The ayes have it. The question is that I do report the bill as having passed committee stage. But not yet, you don't hear the number of announcements of amendments. We just want to make sure that the total is tallied properly.
Yes, yes. Madam Chairman, you know, we could have proceeded without taking the additional amendments, but in the spirit of cooperation and conciliation, you know, they're taken. I have around 11. 10 or 11?
No, we have 20, so we're
Oh,
just
each
yes.
separate one is
So
taken.
we're double
Okay.
checking the count
Okay.
just to make
I'll
sure
count.
that
Yes.
the number of amendments
All
is in fact 20.
1, 2, 3, 4, 5, 6, 7, 8, 9, 10, 11, 12, 13.
So I do report the bill as having passed committee stage with 20 amendments. Those in favor?
Aye.
Those against? The ayes have it. Thank you, Marshall.
I forgot that the deletion and the substitution are counted separately.
No.
20?
20. I do report the bill as having passed committee stage. We're back in the House with 20 amendments. Minister, would you be so kind to ask for the third reading of the bill?
Madam Speaker. Madam Speaker, I now ask that the bill, entitled the Bail Act 2023, be read a third time.
The question is that the bill be read a third time. Those in favor? Those against? The ayes have it.
A bill entitled An Act to Repeal and Replace the Bail Act and to provide for connected matters, read a third time and passed.
House Leader.
Madam Speaker, I beg to move for the suspension of the standing orders to enable me to take the motion, notice of which I gave earlier.
Those in favor? Those against? The ayes have it.
Madam Speaker, the time being what it is, and having tabled the report, the interim report of the Integrity Commission Oversight Committee of the Parliament, and having regard, Madam Speaker, to the voluminous nature of the reports and the fact that we actually dealt with 7 reports today in addition to the annual report, which required a little more detailed investigation. In fact, the nature of this report, Madam Speaker, as it indicated, is interim. But it was so designed to fulfill the requirements of Section 36, which empowered the referral of the annual report to the Oversight Committee for report back to the House within 30 days. So, Madam Speaker, given also that we are going on recess today, it was necessary for the committee to meet and for us to make this interim report and then to take a deeper dive in the new parliamentary session and to report more fulsome to the House. In the interim, it will be useful to consider that among the recommendations that are in this interim report, Madam Speaker, is for the House to approve for a strengthening of the Oversight Committee by virtue of providing technical support of a legal nature in particular, and for us also to look at some other kind of architecture that will allow us to have a stronger ability to respond to the reports, because it is expected, Madam Speaker, that the reports are going to be coming more furiously, if you will, as we have indicated to the Commission that they can report and should report to Parliament every day if needs be in terms of the investigation that they are doing. Because one of the strongest commitments that we want the entire country to appreciate is that this Parliament is here to uphold the principles of democracy, transparency, and integrity. And under my chairmanship, I already stated and will state again, we will fulfill our commitment to the people of Jamaica. Madam Speaker, this Parliament appropriated some $1.5 billion to enable the Commission to carry out its work and to be able to function effectively and efficiently. And we are going to hold them to that in all its forms, while ensuring that the rights of the citizens of the country are protected equally in all its form. May it please you, Madam Speaker.
Thank you, House Leader. As it relates to the Minister
Madam
of
Speaker,
Finance,
I beg to move that the report be approved.
the question is that the report of the Joint Select or Oversight Committee for the Integrity Commission be accepted. Those in favor? Those against? The ayes have it. Will Minister of Finance be? Asking for recommittal.
Madam Speaker, I have to repeat this because the mic was off and Hansard would miss this element of our deliberations. Madam Speaker, I beg to move for the recommittal of the item presentation of bills without leave of the House first obtained to enable the Minister of Finance to take to the next stage the bill he presented earlier.
Those in favor? Those against? The ayes have it. Minister of Finance. Minister of Finance.
Madam Speaker, I now move for the suspension of the standing orders to enable me to take first reading of the bill, notice of which I gave earlier.
Those in favor? Those against? The ayes have it.
Madam Speaker, I now move to introduce and have read a first time a bill shortly entitled the Financial Administration and Audit Amendment No. 2 Act 2023.
A bill shortly entitled the Financial Administration and Audit Amendment No. 2 Act 2023, read a first time.
Madam Speaker, I beg to give notice of a second reading of the bill.
Madam Speaker, it is not intended to do any further business for the day. Madam Speaker, it is not intended to do any further business for the day. The motion for adjournment is before the Honourable House.
Madam Speaker, I rise on the motion of adjournment for the purpose of discussing a definitive matter of urgent national importance. The motion is as follows. Whereas Section 93 of the Representation of the People's Act states that every person who at an election applies for a ballot paper in the name of another person, whether the name be the name of a person living or dead, or of a fictitious person, or who having voted once at any election applies at the same election for a ballot paper in his own name, shall be guilty of personation with the meaning of this act. Whereas Section 96 of the said Representation of the People Act refers to aiding, counseling, or procuring the commission of the offense of personation, whereas the member being the leader of the opposition and president of the People's National Party uttered the following words to supporters. Every comrade who voted for the People's National Party in 2011 and delivered the victory, if they are still alive, they have to go vote. If they have to go vote for Comrade Patrick Peterkin when the election called. And even some who not alive, you know if them can deal with it, no problem. Quote, whereas the members sought to aid, counsel, and procure the commission of the offense of personation, whereas the member has admitted to uttering the said words in breach of Section 96 of the Representation of the People's Act, whereas the clear and unambiguous meaning and intent of the words uttered were to incite and encourage supporters of the political party for which the member is a president to engage in an offense of personation by voting in the name of dead persons in breach of Section 96 of the Representation of the People's Act. Whereas the people of Jamaica, including supporters of the Jamaica Labour Party and the People's National Party, have sacrificed life and property to ensure free and fair elections, one vote for one man to uphold our democratic principles.
whereas a statement of the Leader of the Opposition seeks to undermine the Constitution, the democratic process, and efforts of the nation to ensure free and fair elections and the preservation of our democracy. Whereas the circumstances where the member, by his own admission, has breached Section 96 of the Representation of the People's Act, he would consequently be incapable of serving as a member of the House of Representatives for 7 years in the event that the member was found to be guilty. Whereas the member's conduct is not in keeping with the democratic principles to be expected by the members of the House of Representatives. Whereas the member should forthwith be named and called upon to unequivocally apologize to the nation, failing which the matter should be referred to the appropriate committee of the House for suitable action. Thank you, ma'am.
Madam Speaker, you know, the member seems to be wanting to be judge, jury, and executioner. As I said earlier, and it is unfortunate, Madam Speaker, because the member rose earlier in the House and he has been given a second opportunity at a second bite at the cherry. But as I said earlier, Madam Speaker, that the Leader of the Opposition never in his presentation on that platform outside of this House impugned that there should be any breach of the electoral laws. And let me remind the member that it is the People's National Party who has strengthened the electoral laws and strengthened the Electoral Commission. Madam Speaker, it is a release was done yesterday by the Leader of the Opposition in saying that his presentation was taken out of context. And I can say, Madam Speaker, that the Leader of the Opposition will address the matter at a later stage. If it is that the member is talking about naming the member, we have members just today who have brought committees into disrepute, who have named persons who are members of commissions that are a feature of the House. And if that is the case, then if we are going to be even-handed, as the Speaker said earlier, then I believe that other members should be also named. Yeah? But, you know, Madam Speaker, many a times that we say things on the platform. Many a times we come inside here and we make them so political. And I would just urge the members on that side. Urge the members on that side. Sometimes don't try to make sense out of nonsense and make it political for your own purposes. Madam Speaker, the Leader of the Opposition will speak at another time on the matter, not necessarily in the House. But as I will repeat again, that the party had done a release yesterday, which I think would have covered the matter.
Madam Speaker, yeah. Madam Speaker, I beg to move for the motion to adjourn this Honourable House. But just before we do, Madam Speaker,
Madam Speaker, I'm sorry. I'm very, very, very sorry. I didn't realize that you were moving to adjourn.
To begin with, Madam Speaker, just for good order, this is not a debate. It's a motion that was moved at the motion for adjournment, and therefore it would be considered as a motion to be presented properly to the House in due course, at which time a suitable debate would ensue. So it is just a privilege to the member on the motion of adjournment, but not intended to be a major debate. However, Madam Speaker, it can be allowed for the member to make a comment if he so desires.
House Leader, since you are so wonderful and courteous, Member Brownberg.
Thank you very much, Madam Speaker.
No more than 3 minutes.
No, no more than 2 minutes. Madam Speaker, as one of the individuals who was actually on the stage when the leader of the opposition spoke, and therefore I was privy to both the context and the word, what the member is alluding to or is alleging is not based on fact. It is not based on fact. We would have also seen, Madam Speaker, in the public domain, photographs of individuals driving on their phone, talking, members of this House, breaking the red light, coming out of their car, going back, breaking the red light. We did not believe that those were anything worthy of being brought to the House. In fact, many Jamaicans do believe that amongst us sitting here today are individuals or is individual who would have taken a stool and beaten a young lady. But that was not cause for concern. And no, man, it wasn't cause for concern. But this one is. But this one is.
House. Member Brownberg, I remember I had this conversation with you in another space, and once we go there, then we are going to open a nice discussion about both sides of the House and the issues surrounding the matter in question. I would recommend that we don't go further down that path unless we would like to investigate and ventilate across both sides of the House. Continue to give your statement.
Madam Speaker, I'm about to wrap up. The point I'm making is precisely what you have said, though, is that we should not entertain any hypocrisy.
It's not because of what I've said. Hold on, member, I will ask you to caution.
No, Madam Speaker, I want you to listen carefully to how I have worded my statement. And I am saying that I would not want any of us to enter into the realm of hypocrisy when we deal with a matter that is as important as upholding the law and making sure that we act as Jamaicans want us to. Madam Speaker, the People's National Party, as was noted by the member, which is the party led by the leader of the opposition, did put out a statement yesterday reiterating our commitment.
Time.
Madam Speaker, as the member correctly said, as the member correctly stated, she wishes to just close her presentation. Yes? So we'll allow for just a closure, since, yes, as we say, it's not a substantive
No, the
debate.
point I was simply making is that the People's National Party, the leader, the party which Mr. Golding leads, actually gave a statement yesterday reiterating our full and unequivocal commitment to a free and fair election, as we have been doing over the last couple of years, where Jamaica now has a system that is the envy of many. And it was made very clear that Mr. Golding did not, in fact, call on dead people to go and vote.
Madam Speaker, in the context of Madam Speaker, in the context of how the tradition of this great House has ensued over time, and when we get to this moment when we actually have had a very strong and ebullient and very vigorous period of debate and exchange of ideas and cut and thrust of the democracy and the adversarial democracy that we embrace, and that we like so much, and that we will not exchange for anything and any other. Madam Speaker, this Honourable House has had a number of exciting meetings. We've had a number of committee meetings. We've had a number of joint select committees and sessional committee meetings. And we indeed have deliberated and passed a number of pieces of legislation. And Madam Speaker, it is a long, hot summer that faces us. The climate change realities are on us. And the indications are that it is going to be a pretty warm summer. So this evening, we didn't want to get it too warm, so we walked back out to this honourable chamber into the heat that is outside in physical terms. Madam Speaker, on a lighter note, we really want to ensure the camaraderie that we've had over the period to extend itself now into the lighter moments of our convivial activities. And as we go to our families that have lost us so much, you know, hours that we've spent in this honourable house and away from them, we want to wish that members do find the time to bond a bit with family and with friends. Difficult as it may be for some of us. As in my own case, I still will have to be driving the market because the summer is one of the strongest seasons for us in terms of tourism. But, Madam Speaker, we want to wish each other a very pleasant and happy vacation. This House will be on recess as of today for possibly 4 to 6 weeks. And I make the point against the background that we want to do some repairs to the House. We want to bring back the commodiousness, if you will, of the chamber, and to bring the pre-COVID look, but with a flair. We've had some difficulties during the period, and I think we've used facilities to the point where it's almost in disuse, and we have to restore the usefulness of those areas. So it will take a little bit, and so members, we hope that the team will move very quickly. The sound in the House, you know, has been a real challenge. We want to repair that and to put it in good working condition. We want to rearrange the furniture inside and to make the House far more commodious. And we were fearful that it would get a little sick. So we want to attend to some of the areas of the House that need attention during the vacation. Madam Speaker, as I indicated, it's not intended to do any further business. I now invite you to adjourn the House for a date to be fixed.
This Honourable House stands adjourned for a date to be fixed. Those in favour? Those against? The ayes have it.